when I file an application to adjourn the same, he rejects and he has posted the matter on 19th, madam. I'm sorry, madam, on 14th, madam.
But for what?
For recording of evidence. Madam, here what had happened, after the complainant's evidence was closed, defense witness when was going on, the complainant filed a petition that I want to put another witness. I objected that unless my entire evidence is closed, that cannot be taken into consideration because here the evidence has been closed since last 1.5 years. He allowed that application, which is not supported by evidence.
So, all right, we will, even if it proceeds, then we will see.
It comes in, the entire CORAM becomes infected. I am saying.
When the date is?
Well, it is on 14. If you are option.
30. Okay.
Even the entire.
You give 13. Yes.
Item 5 in the list.
5.
5. Can you take a list? Just add
Case 3927.
Out मैंने पहले 62, 64, 65 similar issue.
that can be a similar one.
ऐसे नहीं
Not similar. That
पहले 11 I will adjourn his case when that is not adjourn করে আছে ও
সেগুলো শুধু পরে একটু বুঝতে চাও ওর থেকে এক্সপার্টিজ নাই সেটা
no don't say that
my nonsense no
don't give that consideration 11
similar
সোমবার আছে
what is সোমবার
সোমবার তো 25 তারিখ আছে
admission admission
but what about the other petitions and I am adjourning this to 20 so when the matter will come you just tell me
সেগুলো কমিটি হয়ে গেল আমি স্যার তুমি কি আমরা পিপল তো দিলাম ওকে দিস ইজ
let us see I am adjourning it to 25th I am adjourning it no
more personal
I understand it but it's not possible because see see how difficult it is to adjust the board, you know. It is easy for you to come and take an adjournment.
No.
Then the back office is under severe tension on this. So therefore, let it be. We will adjust our dates. And generally, those who ask for adjournment, I keep it in December. Because if you are there, therefore I am doing it.
Pardon, Your Lordship.
I will plan to mention lordships. 76 of the compromise matter lordships. 12 o'clock, 2 o'clock. 2 o'clock. Lordships usually 12 o'clock. 12 o'clock, no problem. Yes, no problem.
My lord, item 6, my lord. My lords, beg pardon, my lords, I am on BC, my lords.
Yes.
Item 6, due to some personal difficulty, can it be taken up next week, my lords?
Next week may not be possible, but I'll adjourn it. Okay? I'll adjourn it.
Pardon to mention.
Okay.
Your Honor, criminal miscase 3927 of 24. It is against an order passed under 205 by the trial court and bailable warrant has already been issued, Your Honor. So I am apprehending arrest any time. So I'll be obliged if it is listed to Monday.
We want the cancellation of bailable warrant.
Sir, BW has been issued.
Bailable, what is the big deal? You can go and appear. What is the offense?
Sir, it may end up in because I am unable to attend in the court because of my old age and sickness. I am an old lady of 65 years.
What is the offense? What is the offense?
Offense is 498A 4 DP.
Okay. List it tomorrow. Monday.
Your Honor. Obliged.
Beg pardon, my lords,
Give
item
the number, sorry. Yes, Mr. Singh. What is his name? Mr. Chabra.
Sir,
Mr. Chabra.
sir,
You have to please give the number.
sir, criminal miscase 3927.
3927. Okay.
3927.
pardon, my lords, item 6, can a date be fixed, my lords?
Yes, date will be fixed. Item 6 से date fix हो तो ठीक है.
Pardon to mention, my lord, item number 49.
49.
Yes, my lord, mediation program, mediation proceeding is fixed on 18th of this month.
Mediation is still going on and it is now fixed on 18th.
My lord, kindly after any
18th, then? 18th of please the matter after 18th. Any date after 18th. Yes.
With the lordship's kind permission. With the lordship's kind permission. My lord, I have mentioned this matter earlier also on 23rd and your lordship fixed it 29th. Then again 29th I mentioned it was fixed on 6th. Somehow both the occasions the matter could not be listed. Very sensitive matter, my lord. Bahanaga train accident matter, that Coromandel Express train accident criminal revision case is filed, my lord. 441 of 2000.
Yes, which order?
No, it is a discharge application against discharge order. because these people were they are employees of railway employees and they are engineers and they are not at all. They have already obtained bail by this honorable court, a coordination of this honorable court. Now criminal revision is pending. The trial is going on very speedily, and on 18th and 19th the trial is there. 18th, 19th the cross examinations are there. So if your lordship kindly fix it off on next week anytime, my lord. On two occasions it has been not
No,
listed
no,
somehow.
next week, I don't know. 14th.
My lord, one is already fixed. There are two criminal revision petition. One is already fixed to 11th. And if
But
lordship,
then, if one matter is there on 11th, then let it come on 11th. You give the number of that petition. Which is fixed on.
my associate is there. He will provide
You
you.
give, who is there? Then nobody is there. You give the number,
Yes.
if on 11th, the connected is coming, I'll list that.
395 and 440, 395 and 441 of both are 2020.
Yeah, somebody has to give the number, nobody is
Yes,
there.
yes, just now he's giving.
Yes,
Yes.
okay. Yes,
Kind permission was item number 47. I have applied for the certificate. There are some defects 2 weeks after my lord.
what, certificate copy of what?
Order of cognizance as well as I have filed the Xerox copy. There are some defects. Only
I will inform you. Certificate copy is not required. If you have already, you tell me.
a copy.
Then you give it, I'll let you know. Okay, give it. Okay.
Item 47, my lord.
Okay.
Item 79, my lord.
Obligement.
In this matter, senior counsel Ashok Kumar has been engaged. He has been to Puri because of some trouble in his family. So Lordship may call this matter next
The
week.
personal
79.
difficulties of Mr. Ashok Mohanty, Learned Senior Counsel, an adjournment is sought in the interest of the judge. Yes.
Next week, Lord, only.
Next week, not possible.
Then one chapter because the only.
No. We will adjust the date according to our rules. You can't come and ask for adjournment. See how difficult it is, you know. And even will seek adjournment, I am saying thereafter.
That's to Lord.
And people are waiting in queue.
Only your Lordship's appreciation.
See, we accommodate in personal ground of lawyers, no problem. You have to also understand the difficulty this side. Is it not your responsibility?
That's true, my lord. It's true.
So let it come at देख के दे दूंगा. ठीक है. Next.
Item number 4, my lord. I have now received the certified copy of the my lord charge sheet. I may be able to file it. My lord may take it.
Mr. Chandler, counsel for the petitioner submits that he would be filing the copy of charge sheet within 2 days. Leave the matter after 1 to each. Yes. Yes. Any mentioning anywhere? No. Yes.
Item 1.
Yes.
Item 1. I filed this CRLMC for quashment of the entire criminal proceeding. In the meantime, my lords, the injured, the informant, and the doctor have been examined. They have not whispered a single word against this petitioner.
But you have only filed the copy of
Right now, I am serving a copy of the evidence.
And see, if they have not said anything, you will be able to go. Where is the question of
Since long,
you tell me some evidence is going on in the court. In a 482 proceeding, you have filed the 482 proceeding annexing only FIR. And you want to give all the right now is all the evidence. I will appreciate the evidence. What is the value of that? And cutting it there. Only because my lord, the injured may be because the trial is going on. And at this stage, you have filed a 482 petition seeking quashing of FIR. And in the petition only FIR is annexed. You want that the evidence which has come on record, I will appreciate in this proceeding.
Then you will also must explain
That is a better idea. How many witnesses are there?
My lord, only my lord for accused, what I have taken instruction today morning for accused statement, it was there.
Oh, then it is there. Right. Although the petitioner has filed the present petition seeking quashing of the entire criminal prosecution initiated against him relating to CT case number 30 of 2022, arising out of Sahid Nagar PS case number 400 of 2020 on various grounds. But he doesn't want to press this petition at this stage because the trial has already proceeded and all the prosecution witnesses have already been examined, and the matter is set for the recording of the statement of the accused under section 313 CRPC. In view of the same, learned counsel for the petitioner submits that it would suffice if the direction is given to the trial court to conclude the trial as expeditiously as possible. The petition is posted up with a direction to the trial court to do well to see that the trial is concluded as expeditiously as possible by not giving unnecessary adjournment to either defense or the prosecution side. With this observation, the petition is disposed of. Yes, next.
Within 1 month, you'll dismiss.
No. That I don't know. Yes.
The lawsuit says directed him to produce the CD. CD has not come as cybercrime manner. So I prefer say sort of.
Mr. Jena, for the petitioner submits that he has not received the CD as directed by the court.
26.
Hence seeks an adjournment. Leaves the matter after 2 weeks. 2 weeks. Awaiting the CD. Yes.
May I pay your lordship? I am filing the appearance memo of the senior counsel. Yeah, that this may be.
Where is civil counsel?
He is there in another court. He requested me for Passover since my learned friend is sitting.
Appearance.
Yes, sir.
Appearance of
Mr. Davendra Naik.
Item 3.
Present petitioner, my lord, filed his application for quashing the entire proceeding on the ground that similar footing under co-accused proceeding has been set aside by the Honorable Court, my lord.
True.
Case is like this, my lord.
Yes. So, one co-accuser?
Yes. Case is like one co-accused, my lord. Present petitioner, clinic was read by the CWC, my lord. Jago Singh. That he has procured 2 infant, my lord. In the meantime, my lord, but on Lord the FR 27/7/18, they did not arrest him, my lord. He arrested the present petitioner, Dr. 80 years old, arrested, and I have filed in 2020 a criminal news case, my lord. Filing of charge sheet. There are 0320 he has arrested me, my lord. Subsequently, after 7 days, I got bail, my lord. Then what happened in the meantime, my lord? The 161 statement, my lord. Kindly have a glance. Page 24, my lord.
24, yes.
Page 25.
Message, you got it.
Similar thing,
Co-accused. So in the case of co-accused,
allegation, I guess, co-accused, my lord.
I'll issue notice, let him examine, I'll put it after one. Right now. Also for the petitioner submits that the case of the present petitioner is directly covered by the judgment dated 18/8/2023 passed by the coordinate bench in CRLMC number 209 of 2023. Issue notice to issue notice. Mr. Jana, I accept notice, waives notice, and submits that he would examine the applicability of the judgment cited at the bar and retort accordingly. On the next date of hearing.
One line. Allegation against the petitioner, he has sold the child to the co-accused, my lord. But co-accused, my lord, was received the child. Yes.
And what is the proceeding?
I'm stage of the proceeding. Just keep it next week.
Next week, 1 week after. 1 week after. And in the meantime, the proceeding reports also is state.
Proceeding of the status of the case.
Status of the case will get. Status of the case, everything we will be ready. Yes.
Yes.
I stayed the proceeding also. Yes.
Item 7.
Let's stay here for the proceeding.
I stayed.
No.
Yes.
7.
Yes. Compromise method. Passport.
Item 8.
7.
Yes, sir.
May I please, your lordship. Malad, last occasion your lordship called for up-to-date CD. My learned friend will say whether CD has come or not.
Is there, yes, Mr. Jana, do you have the CD? Change of guard, you have to give one opportunity.
Yes, your lordship. Absolutely.
After 1 week,
Yes.
everything CD, yeah, everything CD after 1 week.
8 and 9 same, my lord.
8 and 9, both.
Same PS also.
Now, PS also same, you please.
Same PS.
Mr. Jana, please note it down so that make sure that no further
I will send
examination.
lordships next time, I will not take time. On the ground.
And new assignment.
New assignment also.
Aye.
Because the last part of the,
Anyway, but now you have to, streamline everything. It will take a week or so, then everything will go.
Oh, that your lordship.
Yes.
Central government different. Public no, my lord.
10.
Because yesterday, before your lordship, the state was directed to take instruction whether they are sellers that.
Yesterday, lordship directed me to take instruction whether on the basis of the passing of the NGT order.
Yes.
That is the sole point, my lord,
Yes,
whether
yes.
NGT order is still exist or not.
Hmm.
And as per my instruction, my lord, the state has not filed any writ appeal. But
Retopil ka nahi, upar ko jibo na.
नहीं रीट अपील गोटे कौन से
Criminal tabra.
यही केस रो जो केस रो बेसिस रो एफआईआर
I think, Mr. Swadding is not,
ना yesterday
I was not there.
my lord was माने inclined to class the proceeding but he has the court has
no, there are issues. You have to be considerate in this. I'll tell you what exactly running in my mind. NGT, the matter went to NGT. NGT passed a detailed order. In the penultimate paragraph, NGT says that we suspect something. So therefore, a case has to be registered. Case is directed to be registered. On the strength of that judgment of NGT, now the case is registered. These cases are registered. Meanwhile, the company, the directors against whom the cases are registered, the company had challenged that order in the High Court. And the High Court set aside on the ground of principle of violation of principle of natural justice and remitted it back to the tribunal to decide. So the according to them, according to you rather, the basis of the registration of the FIR, that is the NGT order, is now not in existence. So therefore, the entire proceeding falls. That the edifice is broken. But one issue which has to be addressed by you, rather they will raise that issue. On the ground of principle of natural justice, the High Court has set aside. But for the purpose of registration of a case against a particular accused, prior to registration, hearing is not required. Insofar registration of case against a particular accused is concerned, whether principle of natural justice is required to be followed? Answer is no. Answer is no. Therefore, if the High Court quashes the NGT order only on the ground that the principle of natural justice is not followed, that may be suffice for the NGT case, which is remanded. But insofar as the criminal case, if a cognizable offence is made out, and accused need not be heard.
At that stage.
At that stage.
Your lordship.
So therefore, how will you attack that on that ground?
You want a lordship experts from us. Now, number one, my lord.
I will not expect anything. You have to satisfy me.
My lord.
This is the question I am putting.
We will satisfy regards to.
If a cognizable offence is made out, it is reported. Source is not more important. It can be registered. The NGT order may be the source. But NGT order is quashed by the High Court, only saying that the principle of natural justice is not followed. Principle of natural justice quashed the NGT order for NGT proceeding, not for the criminal.
Yes, I got your point, Lord. Now question is, our case, if you are supposed to the natural justice part, let us make a passing reference to
ମୁଁ
that.
ଗୋଟେ ରିକ୍ୱେଷ୍ଟ
It is still worse.
ଆମେ ତ ଫାଷ୍ଟ ଆସିଛୁ ଫାଷ୍ଟ କେସରୁ ଷ୍ଟେ ନୁହଁ ଲେଟ୍ ଫାଷ୍ଟ କେସରୁ ଷ୍ଟେ ହଉ ନେକ୍ସଟ ୱିକ୍ ଆମକୁ ଟାଇମ୍ ଦିଅନ୍ତୁ ସୋ ଦ୍ୟାଟ୍ ପଏଣ୍ଟ ହାଜ ବିନ୍ ରେଜ୍ ବାଇ ଦ
Here enough. I mean, just কথা হচ্ছে, not that you can also be.
It is a legal issue to be
It is
addressed.
to be
You follow what I'm trying, what is, I may not be,
My lord,
I might not be clear.
no, no, suppose it's quite clear, my lord.
So there it is a legal issue.
Your lordship is right.
Don't make it simplified, this thing.
Your
No, it
lordship
is
is
fine.
quite right. Our case as far as natural justice is concerned, still better. We are not parties there.
Not required to be party.
There he is a party.
No, not required to be party.
And moreover,
Because you are an accused. You need not be heard before registration of FIR.
please hold on, your lordship. They have to also address that NGT doesn't allow the to initiate criminal procedure. It's only civil consequences. That is section 14.
So then you have a what case? A cognizable offence is made out, FIR is registered.
On the basis of what?
If the source is NGT order, even if that NGT order goes, a cognizable offence still stays. How will you answer it?
Sayita sir, NGT order also is for the direction of NGT order.
That's what I don't think you followed me what I am trying to. Yes.
The FIR says, as
What is the High Court says? High Court says the principle of natural justice is not followed before the order, NGT passed the order. Therefore, he crosses it and sends it back to the NGT once again.
sir,
That will be the environmental issue, that those things will be dealt with by giving opportunity to the parties concerned by following principle of natural justice. But once a cognizable offence is made out, source is not more important and accused need not be heard before registration of FIR. So principle of natural justice doesn't come in the way.
but parity by not is there.
What parity?
In one case, you lost it from the same FIR.
Maybe, but
That is very important in criminal law as well. That is something to be addressed also.
that is a different, anything is crossed? Any FIR is crossed? So far, no.
What's each other, sir?
Where is that?
Each other course?
No, not crossed. Not crossed. You have not seen the file. Not crossed.
I'll check up that also.
Not crossed. Many matters are there. Now you have to address me on that issue.
May some
Precise. You know, source is not more important.
My lord. My lord, first constitute, under what basis the NGT passed the order, my lord? A joint inquiry committee was formulated, which was directed by the NGT to, that was a fact-finding committee, my lord. That joint committee came to a conclusion that there is some offences by the petitioners, my lord. On the basis of that, the NGT passed that order, my lord. And subsequent to the passing of the order, NGT, my lord, the FIR has been registered. Moreover, my lord, in the NGT, the company was a party. The director was never a party, my lord.
Not necessary.
My lord, then
That is for the violation of the environment and all. For that you have a good case.
there is not a simply,
Rightly, but cognizable offence is made out.
it was a joint, on the basis of the joint inquiry committee report, the NGT passed the order. On the basis of the NGT order, the NGT directed as similar to register FIR, my lord.
You have to examine, please examine it. You have to examine this issue on the light of criminal jurisprudence. Don't go in the NGT committee and all. Take for an example, a cognizable offence is made out and who is the complainant is not more important. Once it comes to the fore, the police can register an FIR. Some offence has taken place. Source is not more important. Principle of natural justice is not required to be followed. Therefore, I am asking this question.
Satisfy your lordship.
You have to address me on that. Okay.
The meantime,
I think you followed what is running in my mind and you just.
certainly, my lord.
And you also, I framed the question for you. You have to, yes, simply adjourn it.
Lordship, the first particular stay of the proceedings, my lord. In the detail is just first
Yes, stay of the proceeding. When stay nahi tab stay karo diyo.
my lord.
আমাদের অক্ষী exception of.
That is extended and insofar as the other matters are concerned, stay up for the second. Yeah, stay nahi tha stay karo. Stay kar diyo and leave the matter for final disposal on give a date where I can hear at 3 o'clock.
Yes, your lordship is right. The Read petition.
I read it, therefore I'm saying.
Read petition that has quashed. Read petition has.
For that reason-
has quashed.
You read the writ petition order. It says that principle of natural justice is not followed, therefore I am quashing it and sending it back. And in for criminal jurisprudence, principle of natural justice is not required.
But we are on the other side. I was not see a lot.
It's a difficult question to be answered by you. Come with judgment and.
Next time.
Date, fix a date where we can hear at 3 o'clock, fix it and address it.
7 December.
77.
77 also?
7th December.
Or 7?
7 is on Shanibar order. No, 7 or
Let these youngsters work for that. This is a proposition of law, they will do it, don't worry.
Let it be.
Your juniors are more competent, no, don't worry.
I know that.
Let them do.
In this country,
Let them do, you sit in the back, these youngsters
I
are.
may not be there on that day.
Can it be on the second week, my lord, on the 13th, my lord? I'm fair, my lord.
No, Saturday, I want the Saturday.
Saturday, which is.
I have some personal difficulty, my
Then
lord.
make it 30th. 30th.
ଆରେ ଏଗୁଡା କଣ ହଉଛି ଆଗରୁ ଆମ ପ୍ରୋଗ୍ରାମ ଫିକ୍ସ ହେଇଛି ସଟରଡେ ଗୁଡା ଆମେ ବାହାରକୁ ଯାଉ ଅନ୍ୟ ତ ସାର୍ ସେ ସଟରଡେ ଗୁଡା ଏମର୍ଜେନ୍ସି
That is substituted by these 2 days, है ना?
ଏମର୍ଜେନ୍ସି ଡେ
Emergency.
ସେଗୁଡା ନର୍ମାଲ
चलो गुड देख के दीजिए देखिए let him adjust the board adjust
interim auditor
entry mode
Grateful, my lord.
Item 11, my lord.
but I want effective assistance
Yes, my lord. Wait, my lord.
don't tell the general principle.
Never.
I have called out the real question, you would answer that.
I will.
Yes.
Grateful.
11, my lord. Pass over, my lord. Pass it over.
12
What's going to go for the adjournment?
Why adjournment every matter here? You tell me what is this case?
Lordship, this is a case for in this case charge was framed on
Yes madam, tell me what is this case?
charge was framed on 15 November 2022 and this is a case where the person was arrested on the confessional statement of the co-accused.
The charge has already been framed. How can I quash it now? You are pushing for quashing of the entire proceeding after charge is being framed.
Lordship, it was there for the point of law that in this at this stage the proceeding can be quashed or not. Last occasion, your lordship wanted to know.
That is what I wanted to know. In your file, you have invoked 482. After the charge has been framed, you file a revision and the revisional jurisdiction is there for you. Charge has already been framed.
Lordship,
When is the charge order?
Lordship, may fix a short date. I will.
Where is the order of charge?
Lordship, annexure 3, page 34.
34. Yes, petitioner is agreed by the order dated, where is the order? Order dated
15 November 2022, Lordship.
15th November
2022.
22, whereby charges have already been framed for LA's offense under section 21C oblique 29 of NDPS Act, NDPS Act. The petitioner has invoked the inherent jurisdiction of this court under section 482 CRPC, seeking quashing of the entire criminal prosecution initiated against him. Since the charges have already been framed, petitioner has other remedy available under law. Therefore, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to resort to the remedy available to him under law. With the observation, petition disposal. Yes.
13
May I please?
Certified copy. Certified copy filed in this proceeding may be returned. by substituting the photocopy. Section 14, they are already litigating in wrong forum in a wrong proceeding. Time consumed, will be deducted. Yes.
May I please, Your Lordship? My Lord, in the present application, the petitioner is the wife of the principal accused. She has challenged the order of taking cognizance for the offence punishable under section 13(2), read with section 13(1)(e) of the PC Act and also 109.
Show me the charge sheet.
My Lord.
Why is not signed? I have asked the registry not to register the petition where cognizance order is challenged. If charge sheet is not filed today, 500 rupees you pay to the bar. Okay, because you have, the young man I can understand, not you. Okay. Today I will file it. You file it, huh? You want to file additional document, huh? Additional document after 2 weeks. Yes.
But I short date.
After 2 weeks. Short date December. Not nothing is available. What to do?
Can be disposed of. Well, also can be see.
Yes.
Page 5, para 6.
13? I have 13. Page 5?
Para 6. 109, wife, and the please there.
Sorry, page 5, huh? 5, no. Yes?
Para 6, para 6.
That is only submitted that while the land court below was pleased to take cognizance of the offence against
Income tax assessors is paying tax discrimination from sources of income, private tuition, salary business.
Ah,
My Lord, your lordships is exactly like this case.
not exactly.
My Lord,
That is this
merely because
not covered.
merely because he's the wife for the
I know this judgment.
otherwise I could have.
This only judgment is coming that if you have a separate
My Lord, other two judgments your lordship passed that they are not communicated. Naturally, my Lord, this honorable court judgment in 2017-66 OCR 622. By Honorable Justice Pratima Behera.
Pratima
Behera.
Pratima Vera.
Pratima Behera.
Pratima Vera case, that is also different.
Merely because the entire family also cannot be arranged accused.
No, it's not like that.
But
It's not like that, sir.
the present case is squarely applicable.
No, it's not superior. The difference is, I'll tell you, the theme
My lord.
difference is, under the aid of 109, if the wife is prosecuted, if the wife doesn't have a separate defense, then under the aid of 109, you can't prosecute. If she has a separate defense, apart from the defense of what the husband is portraying, then that defense has to be established in the trial only. That's the distinction in this judgment I have given. In that case, what had happened is, the wife comes and says that I am a housemaker and that is I have no income. Whatever property is acquired, it is my husband's property. I have no nothing.
And the marriage is
In
nothing.
that case, I say, then if it is husband property, husband income, husband has to prove what this lady will do. So, she is taken out. But if the wife comes and says, no, I have independent income, it is not my husband's income and all, then she has to prove that. That's the distinction.
Right.
And you have a separate defense. You are putting forth separate defense saying that I have separate income, these properties are acquired by me from my own source of income, then that has to establish. That has to be established, right? The petitioner is seeking to withdraw the petition with a liberty to raise all the point at, before the court below at the appropriate stage. With this liberty, petition is disposed of. Yes. You file a discharge petition, maybe this judgment.
My Lord, but in Pratima Behera case, the petitioner is a income tax assessee, everything discussed.
That may be different. You file a discharge petition. It is only cognizance.
My Lord, that observation.
Yes, I have given that. File a separate discharge petition,
Well,
relying upon all the judgment, you may persuade the court. Because all evidence will be there. Here you have only filed the copy of FIR. And before the trial court, everything will be there. Well, the judgment you can very well. Yes.
Some talking to Lordship was on Monday has partly had it. It is regarding that possession of pistol which was seized and I had taken him for, he had taken, given him for a purpose of photograph.
And got instruction.
Order of the court, sir, 6.4.
Huh?
Page 29.
Sorry?
He's referring to page 29 of the impugned order.
That's right, impugn order 29.
It's there.
Yes. What do you want to see?
Sir, but on this protected, the petitioner is the owner of the seizure pistol, but the same is admittedly seized from another person from a public place. The owner handed over such a firearm to other person which is not permissible under law. Moreover, displaying the alleged pistol in the public place and considering the pair made by the investigating officer, it would not be proper to release the seized pistol in favor of the petitioner at this stage. Repetition to life offense after release of the pistol and utilization thereof cannot be ruled out for the interest of states.
That's right, madam. What he says that he is the license holder of a pistol. He had given to one of his friends because they were going for a marriage party. And that man, that boy who is taken from him has fired it. And what is the offense committed? Anybody died?
No. Se dekhela kheli bondhu.
And it was seized. And he says that I had given it, I am a license holder and release it to me. Take an undertaking that he will not indulge, otherwise his license will be forfeited if this is found to be used in any other crime. Simple, I'll record that. If you are found, if the pistol is found to be used in any other crime, henceforth, the license will be forfeited. With undertaking, you file an undertaking by evening. I'll allow. File an affidavit. File an affidavit.
I suggest your lordship may direct, I will file it in court.
No, file affidavit, I'll reproduce that and allow it. By evening. Today only.
After recess, my lord.
Yes. You come with affidavit, saying that give an undertaking that you will not misuse that. And you say that if it is misuse, it is found misuse, then your license will be cancelled. All these things you write. That undertaking I'll reproduce and release. Okay. Pass over.
Your lordship, pass over.
Proper undertaking. Yes.
No, my lord, reply is not necessary, my lord. Here, my lord, the order of the petitioner was convicted for commission of offence under section 138 of the NI Act. The law has been amended and it has been incorporated that while admitting 148, he has to comply with the 148.
148 says that after compensation, out of compensation.
20% of compensation amount you have to pay. That's
20%. Shall be 20%.
20% to be different whether it is mandatory or directory. That part is to be decided. That
has been already.
No, it is already decided. It is the directory. But if the court exercise the discretion, now we have to do it. That's all. And you tell me from the impugned order why this the order is wrong. For what reason?
Yes, sir.
It may be directory, but the court has exercised the discretion and passed the order. What is wrong in it? You simply tell me what is wrong in it. You are convicted after all.
Yes,
What is the take amount?
3,50,000.
3,50,000 rupees. You are convicted, you deposit.
That what I submit that the Honorable Apex Court in case of Jammu Hon'Ble directed that only because of really not depositing the amount of 20% in case of compensation, the right of appeal cannot be deprived of a person. So whether that I have also stated in my petition.
So what is the use of 20%? Then you are on bail. The bail will be cancelled. Go to the custody and your appeal will be heard. If you are happy with that, I'll do that. Your appeal will be heard, but your bail will be cancelled. Either of these two, either you pay or this thing.
I am prepared to pay more.
How much?
10%.
You 10% immediately deposit, for another 10% move application before trial court.
Well,
For trial court, you move for variation of that order, but 10% subject to paying 10%.
10%.
10% you deposit, and for remaining 10% you move application. Renew your application. Petitioner is agreed by the order dated. I am giving that, I'm passing that order. You may be having some financial difficulty, whatever.
No.
Shall I send you, do one thing. Best thing is, you have to pay the check amount, you are convicted. Okay?
In this matter,
1 minute, what I'm suggesting a better thing. You deposit 10%, I'll send it to mediation here in High Court and mediate and finish it up. It's a better idea. Why appeal?
No, I don't have any objection.
For 3 lakh rupees, you must be spending more than 3 lakh rupees
in two cases, that is not total losses or two.
I'll do that. 10% you deposit, subject to paying 10%. I am sending it to the mediation center of Orissa High Court and you settle the dispute and finish it up.
Yes.
That's a better idea. Petitioner is agreed by the order dated 5/7/2024, whereby the learned additional sessions Judge Kujongo in criminal appeal number 5 of 2024 has directed the petitioner to deposit 20% of the compensation amount awarded by the trial court while convicting the petitioner for offence under section 138 NI. The opposite party at the outset submits that he would be depositing 10% of the compensation amount to begin with, and ready to go for mediation to settle the dispute, settle the entire dispute. The land counsel for the petitioner is agreeable to this proposition. Therefore, subject to petitioner depositing 10% before the coordinator of the mediation center of Orissa High Court on or before
Next
on the first date of hearing before the mediation center, the matter is relegated to High Court Mediation Center for exploring a possibility of settlement. Awaiting the mediation report, leaves the matter unsettled. You go and mediation center, that's nothing great. You go, come with the money and pay, and it is ready to settle. What 10%? You may reduce the entire thing. No course of action. In the meantime, no course of action shall.
Awaiting
the opposite party number.
Awaiting the 10th of December.
10th December. Awaiting the report. Do it unnecessary.
In both the cases, madam.
Both the cases. Common order कर दो, correct. And you give some lump sum and some installment and finish it up. Yes.
16.
Obligement.
Yes.
The petition, my lord, and the opposite party number 2,
Yes.
they were married. At the instance of the opposite party number 2, a case of rape was registered against the petitioner.
Number 3 mile, 2 mile. My lord, case is my lord.
Yes.
The true fact of the case, my lord, petitioner is 68 years old. When he is staying in his village road, informant son is about 18 years. He come speedily with bike high speed and hit the chest of the petitioner. When petitioner fell down the road and rescue the villagers, his son and daughter is now in his house. They are outside of the district. Thereafter, they call the members to the petitioner and subsequently call for his mother and brother. They are also threatened the old man to kill him, and thereafter the petitioner was acquired before the local police station. After lodging it, subsequently, while accused person hit the motorcycle to the petitioner, he even as a counter affair. My lord, in this case, my lord, total false case, my lord. He want to file a counter affair, my lord. There is no, his son and daughter is not in the village, so that he only Chandigarh.
So how in this proceeding, how can I decide that?
At least, my lord,
You may be telling the true story, but the true story has to be on record.
yes,
Where from I'll get that?
my lord,
I can't, presume things and decide the case.
issue notice, if there is compromise, then it is compromise.
If you say they have compromised because the allegations are very minor in nature, you can settle the dispute, I can very well try.
Yes.
On merit, you don't have a case.
Yes,
Shall I record your statement that you are going to settle the dispute?
yes, yes. If someone issue notice, then
I will not be a party for your. I will not. You say that I can think of. Okay, learned counsel for the petitioner submits that the allegation against the petitioner are minor in nature. The parties are known to each other and they are intending to settle the dispute. Settle the dispute. Hence, he pray for issuance of notice. Regarding head to the submission made at the bar, I'm inclined to issue notice so as to explore the possibility of a settlement. Issue notice.
Further proceeding, state.
I'm just trying to help you. Don't be helpless. Keep it after one week. Huh? Bring immediately file process fee and bring them. Yes.
18.
Item number 18. This was against the rejection of protest petition filed by the present petitioner. Actually, in the last occasion, this Honorable Court had issued very specific directions.
Yes, sir. Also, as per the order direction passed by the Honorable Court on the 11/9/2024,
Yes.
I have already obtained instruction from the concerned police station.
Yes.
In which is clearly mentioned also, and I am read your lordship that part your lordship.
Yes.
Honorable Court has while in 11/9/2024 specifically directed to the Learned Council appealing for the state to obtain the statement of witnesses and he said also obtain instruction as to whether
In the instruction as to whether the CCTV footage of the spot of occurrence for
Yes, yes.
time.
That effect, my response submission lordship, the I was given. Further, there is no CCTV footage. The traffic police on being contacted failed to provide any CCTV footage at the spot on the day of occurrence. And the spot of the case where the accident has been taken place is not coming under the coverage of any CCTV installed at a Rajmahal. And neither BMC nor any other individual installs the CCTV at the spot where the incident has been taken place. Also. That is the specific instruction so far CCTV footage is concerned.
Yes.
So far statement part is concerned, also, there is a written statement recorded by the police. Also. The complainant informant who is the Pradeep Singh, lordship. That statement I may read, your lordship.
Yes.
More नाम प्रदीप सिंह, बॉयस सोनशो, फादर सर्वत कत्वतन सिंह, स्थान में क्वार्टर नंबर सोनशो, खारबनगर थाना खारबनगर जिला खोर्धा अटे आज 5/11/2021 रिको कैपिटल थाना एसएन नायक बाबू को दबा मोर मौखिक बयान एक जे गतकाली ता 4/11/2021 मुताबिक मोर पुओ प्रतीक सिंह तार भाई स्वयं राउत सह शिशु एवं सपपटू राजमहल पटकू मोटरसाइकेल जार नंबर OD33S3899 आसुवा समय रात्र प्राय 10 घंटा समय राजमहल छक निकट से मोटरसाइकेल दुर्घटना है संगे संगे 108 आंबुलांस जो कैपिटल हॉस्पिटल निगला से मोर पुओ को डाक्तर मृत घोषणा कले डाक्तर स्वयं राउत को आमिनी हॉस्पिटल को रेफर कले आमिनी हॉस्पिटल स्वयं राउत इंजोर्ड लॉर्डशिप तदंत सकाशे रिपोर्ट लिखी थाना जन दिट इज द इम्प्रूवमेंट स्टेटमेंट तो therefore more now another statement is Vikram Kisari Pradhan lordship.
May I just intervene?
Yes, sir.
This is vis-a-vis a complaint case. Police submitted final report. Then we filed a protest petition. That protest.
I understand,
At the cognizant stage, he has conducted a mini trial.
203 invoked and dismissed the.
Yes.
And if there are materials, any kind of materials are there, then cognizance has to be taken. You can't decide finally.
So for investigation, there is no super CCTV footage.
Whenever you have read out the evidence, there is something.
There is accidentally
Let us read 202 statements.
Just to assist your lordships, as a first brush, the court on the last occasion called for CCTV because this happened.
There is no CCTV footage.
There is no CCTV.
Yes.
Since there is no CCTV, they are saying now this order has to be set aside and the matter has to be the trial has to go on. So for that, the private OP probably has to be heard. So if the lordship drops, interferes at this stage.
No, the notice has not yet been issued.
No.
Okay, issue notice then. Because see, it is arising out of.
Yes. I should save time of the court.
Issue notice.
OP number 2.
OP number 2. Yes. OP number 2 and OP number 2 only. 3 is in charge and crime branch. Okay. OP number 2. Okay. Written evidence. There can't be any stay because it is dismissed.
These people have lost their son.
Yes. But what I propose is, according to me, I have issued notice after 2 weeks. I'll set aside the order and remand it back once again. Because there are materialities, you can't pass a final judgment at the stage of taking cognizance. You see material, if there are materials there, it's cognizance, let it be put to trial. Whatever happens, happens.
2 eyewitnesses we have put up, saying that we have seen that they were assaulted.
Even on the basis of the statement of the complainant, cognizance is taken. We have put it to eyewitnesses. And you analyze whether it is veracity of those statements and pass a judgment and virtually equity. That is not permissible under law. You have to take cognizance and whatever the fate may be. So therefore, I'll set aside and without ex parte I can't do it. I'm issuing notice after 1 week. Roko, set aside करके फिर भेज सकते. Otherwise, this is completely clear. Yes.
19.
Yes.
Lordship is challenging that the petition was in bail and after filing the charge the higher offences added. That original challenge for classmate, your lordship. That is the
higher offences are added.
Yes, your lordship.
In the charge sheet.
Yes, your lordship. That is in full notice annexure 3.
I'll pass over. Higher,
yes, sir.
if it is higher offences are added, then the charge stage you can sort it out.
Yes,
whether this case is made out or not. Yes. Pass over.
20.
May I please, your lordship?
Yes, sir.
Sir, it is a vigilance case, my lord.
Yes.
No, 19 pass over.
20 council, I think the vigilance request to pass over. Vigilance council is there.
Rather, your case is pass over. So come. 19.
Okay, 19. Oh, bless me.
Rather, item 20 is pass over.
Yes, sorry.
Reverse manner. Yes. Yes, sir.
My lord, the present case is that earlier the FIR has lodged on the before the IAC Dharmasala against the present petition under section 379, 294, 34 IPC. Thereafter, the charge the final report submitted by the IO and the Lorraine Trial Court taking cognizance under section 420, 468, 413, 379, 294, 120B of IPC.
Charge sheet is filed on that provisions.
My lord. Thereafter, cognizance are taken by the Lorraine Trial Court under section 420, 468, 413.
Rightly so. What to do?
420, 468.
Yes, I understood. I've seen.
413 and 379 and 224, 120B of the IPC. My lord, 420 or 468 is
not wait for according to you.
My lord, only for 13 is the tribal of the Court of Session, my lord.
But your cases, these offences are not made out.
No, yes, my lord.
Where you should argue that? at the time of framing of charges.
My lord.
The court may not frame the charge. If you can demonstrate. How can you question the prima facie case is that? Cognizance is rightly taken. If I am getting a committee, application for trial court, the court should deal with it and decide. Where petitioner has challenged the order dated 4/1/2022, where passed by Learned JMFC Chandigarh in city case number 1412 of 2022, whereby cognizance of offences punishable under section so and so has been taken. The counsel for the petitioner submits that the initial FIR was registered for offences under section 379/294/34. However, after investigation, graver offences have been added in the charge sheet. And subsequent thereto, the cognizance of the said offences has been taken by the trial court. Hence, he is agreed by the order of the court below, taking cognizance of the offences. I am not inclined to entertain this petition at this stage. The grievances of the petitioner can be well attended by the court below at the time of framing of both charges. Hence, liberty is granted to the petitioner to raise all these points before the court below at the appropriate stage. With this liberty, the petitioner is disposed of. Yes, next.
No, let them.
21.
21.
Vigilance. Well, as petitioner before lordship is a chartered accountant. He was an auditor of one company in Raurkela, SAV Industries Limited. Well, it's for the financial year,
Full one of the partners.
well, no, I am not the partner. I am the statutory auditor. I only do audit and submit the audited accounts to the management. That is my duty, my lord.
Yes.
What happened, my lords? Lords will see an inquiry was conducted by the ROC, and the ROC that your lords will please see come at may be pleased to come at page 36. It starts.
Yes.
Inquiry under section 206 bracketed 4.
Yes.
Then, my lords, the relevant portion, how the petitioner has been entangled, that your lords will find that page 39.
39.
Page 39 of that lords will, it starts from page 36 of my brief.
Yes.
And page 39.
Yes.
How lords will see clause 11.
Yes.
That is the allegation that has been made. Violation of provision of 129(1) read with Schedule 3 of the Companies Act. And my lords, what the allegation is that I have not mentioned wrongly the closing stock. That's all.
Yes.
Then, my lords,
Yes.
the auditor submitted its reply, and the petitioner, who is before lordship, submitted its reply denying the allegation. My lords got 206 that section and the then, my lords, what is the allegation that your lordship may see? As per the financial statement for the financial year 14-15, the company has opening stock of stores and spares of 8,25,630. The closing stock of stores and spares is disclosed at 8,20,136. Therefore, the change in the value of shares and spares 5,494. However, as per the additional information to the statement of profit and loss, the change in the value of stores and spares is 13,000 some odd. Then, my lords, this is the sum and substance, this is the allegation. Then I replied, the reply starts,
at from page that your lordship will see, a para-wise reply was submitted. It starts from page. Yes, 46. Yes, I'm there. Yes. Starts and the relevant portion so far as this particular allegation is concerned, my lords, your lordship may be pleased to turn to page 54. And query number 11. Violation of provision of section 129 bracketed 1 read with schedule 3 of the Companies Act 2013. This is first, I have submitted what is the allegation against me. Thereafter, lordship will be pleased to see my reply, auditor's reply. Yes, auditor's reply I have given in the financial year 14. I understood it. Yes. What happened? Now, my lords, the ROC, as per clause 4 of 206, after receipt of the reply, he should have given me an opportunity of hearing. If he disagrees with me, my contention or the reply, what he should do, the statute mandates under clause 4 of 206, lordship may be pleased to see, and placing that section, my lords. 206. Yes. To subclause 4, subsection 4 of 206. Yes, 1 minute. 206, yes. 206. Yes. May I place it, my lords? If the register is satisfied on the basis of information available with or furnished to him or on a recommendation made to him by any person that the business of a company is being carried on for a fraudulent or unlawful purpose or not in compliance with the provisions of this act, or if the grievance of the investors are not being addressed so and so, the register may, after informing the company of the allegation made against it by a written order, call on the company to furnish in writing any information or explanation on matters specified in the order with such time, within such time as he may specify reasonable opportunity being held. Now, before lodging this complaint, what reasonable opportunity is not given, has been given. My only sole prayer before lordship is very innocuous. Let me be sent back to the ROC and let him give an opportunity of being heard. Where have you moved this application before the court below? No, this application now cognizance has been taken. Yes, against the cognizance I have come. And the cognizance also will find at page annexer 1 at page 16. That is my the learned magistrate ballots. He has. There is no bar to take cognizance. No bar. If opportunity is not given, yes, there is no bar. No bar. And that would be a position you can take it the right stage. Well, how will you attack the cognizance order because 2064 is not complied? No, my lords, because as your lordship is aware of the fact, aware of the law that when the prior facie the magistrate, learned magistrate takes an order of cognizance, he has to consider all the facts. But he has considered, see, he has necessary, what he says, necessary documents are received. Well, at the time of cognizance, it's not necessary that the accused should be present or not. Right. That is called right balance. Well, therefore, after taking cognizance, you have to go to the court and move an application. I am giving that liberty, new application. Well, raise all these points and invite a specific order. Well, earlier non-compliance of what is the consequence of non-compliance of 2064? Yes. That will be examined by the court because there is, see, for non-compliance of the procedural requirement before proceeding against it. It's a mandatory matter. But that will not prevent the trial court. How the trial court will have? Correct, my lords. Correct. Whether you have to go to the trial court saying that no opportunity was given. What I, my lords, why I have come before lordships. My lords,
Earlier, in this matter, Lordship may be pleased to see a notice was issued on 9th, 9th of October to the 2024 matter.
Yes.
The opposite party ROC has not appeared, my lords. What?
Service, what is the position of service?
Well, I have postal requisites have been filed, but they have not entered appearance. That is the thing matter. And my lords,
Notice is there. Notice, who is standing counsel? Who is appearing for companies?
ROC, my lords, I am not.
Who is appearing for ROC?
Register of central government matters.
Central government.
Central government. Union of India.
You have to give it to the deputy additional solicitor general.
Balance.
Mr. Ryan, pursuant to the order.
One for 1 second.
Yes.
So Lordship, bear with me. My predicament is there, my lords. Why I am before your Lordship. On 1st of December, I have to give a certificate to the.
Before that, I'll hear. Before
Yes.
that, before that, I'll find it. Pursuant to the order dated 9/10/2024, though the notice has already been served in the register of companies, but none appears for on his behalf. Mr. Rai, senior counsel for the petitioner, submits that he would serve a extra copy in the office of deputy solicitor general by along with the proceeding of this court. Lease the matter for hearing. November master December he has a problem. November the interim order pass on 9/10/2024 shall continue. Till further orders.
Yeah, my lords. What is may I permitted to make a fresh prayer so far as the interim application is
That is there already.
My lords, stay of the because 28 is the date.
Stay is already there.
My lords,
He is not ready. Stay. Complete stay.
Yes.
Yes.
My Lordship is fixing it to November
27 number.
27. Very much obliged. 22.
Your Lordship, the matter may be taken up by Monday, 11th of this Monday. But today not I am feeling well.
I will accommodate you, but don't fix the time according to your.
No, sir, it is urgent.
No, it's all right. You are not well. You can. No. We will adjust our board. It's not possible.
Urgent. Feeling
I know. You take your own time. Don't worry about it. I'll accommodate you. Don't worry.
Sir,
No, it's all right. You must go. You should have requested one of your brothers to. Then counsel for the petitioner is not disposed today. Release the matter for hearing. Yes. You must go home instead of. You must go. Yes.
May I please? 23, madam.
Yes.
Here it is a private complaint, my lord. Offense under the 138 Act, madam. My lord, I am challenging the accused. I am the accused. My lord, here, my lord, I am challenging the order under Annexure 3. What happened here, my lord? The petitioner, my lord, wants to be a witness, my lord, for which he filed a evidence affidavit that has been rejected. You will also kindly see the act, my lord. 145 clause 2.
You want under 315?
My lord.
315.
315 along with my lord. That is rejected, my lord.
Such a big order.
My lord.
Such a big order.
My lord, such a big order. That is Annexure 3, my lord. And thereafter, my lord, the petitioner preferred the revision. Revision was not maintainable in view of the. It is not a final order.
What did you take amount?
15,000, my lord. There is business partnership.
What is this? Give 15,000.
Sorry, 15 lakhs, my lord. Sorry. 15
lakhs.
No, 15 lakhs. Sorry.
Okay.
There is a business transaction between the two where, my lord, my lord.
What is the reasoning? Such a big order. What is the reasoning?
Citing the decision, my lord, of the Honorable Supreme Court, my lord, said that the evidence affidavit is not permissible so far as the accused is concerned. Your Lordship, in that case, my Lord, I am reading out one paragraph. Your Lordship, kindly see paragraph 36 also in that judgment. One of the judgment is there, my Lord. It is judgment of Gujarat High Court. By putting that judgment, my Lord, the Honorable Court said that on this issue, we are afraid that the High Court overreached itself and took a course that amount to taking over of the legislature function on a bare reading section 143, section 145. It is clear that legislature provided for the complainant to give evidence on affidavit and did not provide for the accused to similar do so. But the High Court thought that it was not mentioning the accused along with the complainant in subsection 1 of section 145.
Issued or not?
No, my Lord, fresh matter, my Lord.
Issue notice. Issue notice. In the meantime, the petitioner shall move an application for adjournment owing to the fact that the petition is sub judice before this court. That is how this is how the matters are being delayed. According to me, it should have been allowed.
Yes, my Lord. Allowed on one day, my Lord. Definitely, I will proceed them. This works, my Lord.
Writing so judgment and all. How many pages order this is?
Unnecessary, my Lord. The case is lingering. Your Lordship kindly say annexure 3 and annexure 4.
One matter for rejection of an application, you write 20 pages unnecessary. By the time the matter would have been over.
My Lord.
You know what to do. Issue notice, you move application for and take out notice
by registered post, my Lord.
by tomorrow.
Tomorrow, Saturday, my Lord.
Monday. Requisite to file by Monday. Requisite to file by Monday.
Ma'am.
Okay.
May I please?
Yes.
Passing of proceeding matter on the ground of compromise. Parties are before your lordship.
What are the offenses?
Therefore, I say, my Lord, was the remaining part of the proceeding, my Lord.
Yes, sir. What do you want to say?
What was the matter, my Lord, which is pending before the
Pass one. The grounds.
taking ground, my Lord, the victim and the present person, both have already got marriage, my Lord, and both are living peaceful, my Lord.
Where is the marriage certificate?
The marriage certificate, no, my Lord, I have the affidavit, my Lord, under annexure 2, my Lord, can you see, my Lord?
I mean, before notary, you got married.
Not married, my Lord, affidavit, my Lord.
What is that affidavit? Where are you married?
Well, 15 under annexure 2, my Lord.
The informant.
You have said in paragraph 8 in the affidavit that the affidavit is required for obtaining the marriage certificate from the marriage officer in our favor. Where is that marriage certificate? Have you read your brief or not?
My Lord.
Then tell me and answer it.
I have not annexed, my Lord. Time may be required, my Lord.
Please read your brief.
My Lord.
And then you address, okay? I'm just urging it after 2 weeks. If you think that you have settled the dispute, bring the informant also. Bring opposite party number 2 here in the court, then I will quash it. Okay? Bring it after 2 weeks. Next.
26.
I think 26, your lordship is similar to the matter your lordship heard at item number 10. It is the present petitioners are basically entangled in a criminal case which is arising out of an NGT order.
Oh, the same order Mr. Jana was appearing.
Yes, your lordship.
Same order. I have adjourned it to which date, item 10? 18th December. See, interim order will continue. I have carved out a question of law out of this entire issue, and you have to address that.
Obliged, Lord.
You have to address that. Okay.
Matter will kindly be admitted and tagged along with all the other hearings.
So that matter, yes.
Grateful.
No, stay, that stay. Everybody is getting stay. Why not? Take further proceeding, least, yes.
27,
And pass over, my lord, on the pass over.
28,
In this case,
Yes, sir.
petition number one is a Badaja, two ହଉଛି ବେଉସର ବେଦର ଆଉ ଯାହା ସାନ ଭାଇର ଯାହା ଫାଇଲ କରିଛି ଫଲ୍ସ କେସ୍ ଏଭିଡେନ୍ସ ଯେ ଆମକୁ ଘରେ ମାରଧର କରୁଛନ୍ତି ଆଉ ଶଶୁରକୁ ଖାଇବାକୁ ଦଉନାହାନ୍ତି ଏଫଆଇଆର ଭାଇ ରନିଂ କରି 12 petition not Confiscation made out, I filed a challenge the covenants error by the annexure of
Show me the charge sheet.
my lord,
Show me the charge sheet.
charge sheet my lord, annexure
Annexure 3.
annexure 3 my lord, charge sheet হচ্ছে annexure 3 series.
No, this is some change or something.
What is my lord outcomes?
Where is the charge sheet, sir? Charge sheet you have not filed, it seems. Item 27.
Item 19 my lord, item 19 19
Item number?
20.
Ashok Kumar Behra.
my lord,
Ashok Kumar Behra.
my lord.
Yes.
In this case, my Confiscation made out, FIR allegation my lord, ଯେ ଘରେ ମାରଧର କଲେ ଭାଇ ଭାଉଜ ମତେ ଆଉ ବାପା ଶ୍ୱଶୁରଙ୍କୁ ଖାଇବାକୁ ଦେଲେନି. In this case, no eyewitness, କିଛି nothing. Only for a family quarrel by that time.
Who is the,
Will suit among the parties.
but who is the informant? You have not included informant also. How will you?
ହାତରେ ଲେଖିଦେବୁ ଆଉ.
Everything you do like this.
ନହେଲେ ଫାଇଲ ଗୋଟେ କରିଦେବୁ.
These are online filing, huh? Online filing, you have filed a amended memo of parties.
My lord. Informant କରିବୁ ଲେଖିଛୁ ଲେଖାଇଲେ ଭୁଲ ବାହାରି ଲେଖାଇବୁ.
That is the minimum. You don't do that, what to do? Land counsel for the petitioner seeks to amend the memo of parties. 1 week time is granted to add the informant as opposite party number 2. In the event amended memo of party is filed, issue notice to the related opposite party number 2. We will do it. Yes. Next.
ମାନେ ଗୋଟେ ଆମେ petition ଦେଇଛୁ hearing
First of all, you have not filed a complete petition. You throw any paper on the court and you ask for a stay. How can it be given?
ମାନେ adjournment ଯଦି ଫାଇଲ ଦଉ.
No, you file at least you should not bring
Short date.
short date only. File a complete exhaustive petition, then one can take.
ମାନେ ଗୋଟେ
You file an incomplete petition, you want a stay.
no my lord, short date.
Henceforth, you in a slip you give just file. In a small slip you say give stay. That's all. I will give stay. Why unnecessary filing petition? File complete petition, at least one more party should be completed.
My lord.
Yes.
Item 30,
No, 3. And issue notice, file the process also immediately tomorrow. By Monday you file the process.
My lord.
I have already issued notice.
My lord.
Yes.
They
Notice the requisite to be filed by Monday. To immediate it for subject to adding the yes.
I agree with it.
I notice on I also. Notice on I. Yes. Yes.
My challenge is the second FIR, my lord.
Second FIR.
My lord, first FIR was
29. Item 29.
to 30.
30. Okay.
30.
Yes.
Santosh Naik,
Yes.
my lord. I will challenge with the second FIR, my lord. The first FIR was
Second FIR is annexure 2.
first FIR is annexure 2.
Okay.
Annexure 2, my lord, the column number 6, Rupa Naik, against Santosh Naik. Then, my lord, turn to my lord, running annexure 3, running page 24.
How many FIRs are there?
In same subground, same person, against same person. Wife against husband. First FIR is Medinapur,
You are the admin.
First affair, second, first affair, my lord, running to 24.
You want quashing of for the second one.
First,
What is happening to your marriage?
marriage already in my lord, detachment. Detachment already.
No, have you filed any divorce petition? Not that you are judicially you are separated by any.
No, judicial interim maintenance was given, therefore.
No, you have filed divorce petition.
No.
You are interested to stay with her.
So taking instruction.
And you are not filing divorce petition means you are interested.
Actually, I have two sons.
No.
Two sons.
Right, and I issue notice. Issue notice. Right. Matrimonial dispute. 2 cases she has already filed. Issue notice in the.
They have been acquitted. Man. First case I have acquitted.
Issue notice. Written on so and so. In the meantime, the proceeding arising out of which case?
Annexure 1.
Annexure 1. FIR number. FIR. What is this FIR?
Mahila case
case number 122 of 2024.
1824.
24. Proceeding arising out of so and so state. Yes. And subject to petitioner filing filing repeals by Monday.
Tuesday.
By Tuesday.
With your apology, Miller, item 29 Miller, it's a different matter. Time in an opportunity they are waiting for mediation. It's a 304 with a passment by month. Item 29.
What happened? 29? What was it? Who will mention?
Mediation is
going on.
Mediation can 304 be I seeking a passment of
304 with matrimonial dispute.
That's
Somebody right.
302, 304 B pack. Or the move back passment by on the ground of Miller.
Who are you?
I am the brother-in-law. I seeking Miller passment of the proceeding on the ground of Miller.
Have I sent it to mediation? Then who said mediation?
It's भूल नहीं रही थी वो
some other matter might be. The first matter. I'm not send it to mediation.
First time
in that matter, he said that matter is fixed on 18. So therefore, I said list it after 18. I have not sent it to mediation.
First time.
Somebody else mentioned some other. Yes. What do you want to see here?
Here, Miller.
Who are you? You are the
brother-in-law.
Brother-in-law. Okay.
I seeking Miller passment of the proceeding on the ground of father and father-in-law trial and got acquitted from the charge.
Where you were? You were somewhere else. Absconded.
They have arrested and they.
When you were absconded to what to do?
I annexed the Miller acquittal judgment that is running.
Show me the relevant part of acquittal judgment.
First, I placed the charge sheet, but allegation against my name.
This judgment might have dealt with it.
Yes.
Let us see. 50. So I know that. Where is the finding?
During course of trial, Miller, the informant and relative, that Miller, relatives of the deceased not supported the prosecution case. Then only Miller remains the dying declaration. Since the dying declaration, Miller suffers from the infirmity. It cannot be Miller only the basis of the conviction. That's why the court below Miller got acquitted the husband of the deceased Miller. And more so, I did evidence from the affair, very less allegation against the petitioner Miller from charge sheet Miller, who being the Miller brother-in-law of the deceased Miller. And wherein Miller, it's a case initially 307.
Come to para footing. Para footing of the judgment at case 42. You show me the relevant part. You are not ready.
Move to trial force.
See 14, para 14.
Yes,
I'm doing your job.
Family member.
I'm doing your job.
No.
I'm doing your job.
Yes.
Reading.
The independent witnesses and family members of the deceased, as well as accused persons, have not reported clearly in support of.
Yes, what do you say? They have not, none of them have deposed clearly. So at least he is entitled to bail.
Yes.
You surrender, the court will legally will face the trial.
Yes.
Okay?
Yes.
Because see, the co-accused persons have already been, husband and all, everybody executed. This is the finding. He is bound to be executed, but he was absconding. Because his brother-in-law absconding. Better that he should surrender before the court. Once he surrenders, he should be enlarged on bail and face the trial.
Yes, that is what.
Face the trial. That's the best way of doing it. Right on. Petitioner is the petitioner is one of the accused in the FIR number so and so. The informant, who is the informant? Informant is
Brother of the deceased.
the informant in the present case is the brother of the deceased. The present petitioner is the brother-in-law of the deceased. Brother-in-law of the deceased. Charge sheet was filed in the present case on 29/8/2021, showing the present petitioner to be an absconder. However, the other accused persons, namely the husband of the deceased and who and father-in-law of the deceased, face the trial. The district and sessions judge Jajpur wide its judgment dated 30th August 2024 in CT bracket sessions number 42 of 2022 have passed a detailed judgment, has executed the accused persons, those who have faced the trial. The sessions court recorded the following finding: 42, page 42, para 40. And 50. Para 15. The trial court, after analyzing the entire evidence, even the dying, where is the dying declaration? Dying declaration, your name is there?
Yes, sir. Sorry.
Show me the dying declaration. Show me the dying declaration. No, not required. The finding is already there. 17. Yes. Para 14 and 16. Para 14 and 16. Leave para 15. In view of the weak nature of evidence adduced by the prosecution, the co-accused persons, both the co-accused persons have been acquitted. Relying upon the said judgment of the Sessions Court, the petitioner submits that subjecting the petitioner to trial would be a futile exercise. As there is no evidence borne on record even against him, even against him. I'm not impressed by the submission made by Mr. Pondal and counsel for the petitioner, because the evidence adduced by the prosecution was for the accused person, those who had faced the trial. On the strength of the evidence borne on record, strength of the evidence adduced by the prosecution regarding the complicity of the accused person to face the trial. The role of the present petitioner, the involvement of the present petitioner cannot be elucidated. Therefore, he has to. It is inevitable. Therefore, it is inevitable for him to face the trial. Having said that, keeping in view the nature of evidence which has come on record in the allegation form part of the charge sheet, I am of the point of view that the petitioner should appear before the court below on or before 30th of November and move appropriate application for enlargement for admission to admit him on bail. If such application is made, the same shall be if the petitioner surrenders before the court on the date already stipulated, he shall be released on bail. Bail with the condition as the inscription proper, and also in face the trial. Face the trial. With this observation, the petition is
surrender before the 14th session over.
14th session.
Time declaration ଅଛି କିଛି ନା କହିନି?
No, I've seen it. I've seen the time declaration not believed. And para 16 not believed. Nothing is proved on record. The time declaration is not.
କିଛି କହିନି.
But time declaration is not believed.
Yes, court to believe.
Yes, I've seen it. Yes. 31.
31 days.
31.
Last yesterday we done.
Yes. 31 is also same. Let them come. We'll see. Yes. 32.
32. May please, madam. But very challenging. An order passed by DJ Baliguda Kondhamala. Therein my prayer to release my vehicle under section 457 was rejected. So on the ground that there is a bar in NDPS Act 52A, so the vehicle cannot be rejected.
Where is that order?
The order is the annexure 1.
Yes.
Page number 10, my lord. And the relevant para is, my lord. That is at page number 14.
Page number?
Therein, my lord, learned court below has stated.
Yes.
It may be stated here that the vehicle in question, motorcycle bearing number so and so from which the ganja was recovered, and this is used as a conveyance. The clause 1 of the 52A of NDPS Act specifically provides that the central government may by notification specifically provides that the central government may by notice specify such narcotic drugs or psychotropic substances which shall as soon as maybe after their seizure be disposed of by such officer in such manner as the government may from time to time determine after following the procedure prescribed in the section 52A of clause 2 to 4. Thereafter, learned court below has relied judgment of Union of India versus Mohanlal and another judgment also on Biren Prasad Naik versus State of Odisha. My ground of challenge herein is that the judgment Union of India Mohanlal, this that provides the direction by the Honorable Supreme Court for disposal of narcotic substances that has been seized by the officer during the time of
vehicle.
Yes, and that doesn't deals with any disposal of seized vehicle.
Yes.
My lord, I'm relying upon one standing order of this Honorable Court. Therein, my lord, this Honorable Court has already declared that 52A is not a bar to release any vehicle, my lord.
Yes.
The order is that is a page number 23, my lord.
23.
Yes.
Para 6.
Yes, para 6.
Yes.
My lord. So I'm relying my
The vehicle in question may be.
Yes, sir.
Released by the.
Covered by this judgment.
Another judgment he has referred to.
I have also passed some judgment in this line.
In view of that judgment, the state of Odisha and the Registrar General of High Court has reflected that this court is considered view that the vehicle in question has been used as a conveyance is not to be released under section 4.
Where are you reading? Where are you reading?
That is the finding of the trial court.
What was about, see, he agreed by that finding, therefore he is here. Don't read that to defend yourself. He is agreed by that finding. He says that finding is wrong. That's contrary to the judgment of this court.
But to the judgment of this.
Just see, check it up. Just annex 4.
Yes.
He has filed that. Check it up. If you want to verify if you have a contrary judgment, you tell me.
Yes, I will verify that judgment.
No, my lord, that judgment also Registrar General who is that also deals with any.
I know that is
also relied
that is contraband. That is contraband.
That is also relying upon the implementation of direction given in Moorland, Union of India was a Moorland.
Would you examine it? Because this is not only one case. Many cases will come. So in one case you prepare, then it will, you will be clear. So that for opposition it will be easy for you. Okay. Let him just examine.
Short date may be given.
Short date only.
What happened, my lord? I made a mistake here. I haven't filed any IA, my lord. So, I made it.
What kind of IA? It can't be ruling like this. Finally, it has to be decided. You will not file.
Please, my eyes.
If the ruling decided, you release for interim.
In the meanwhile, if they confiscate.
No, short date can be. And you seek instruction whether you confiscation proceeding has been initiated or what. Yes. Yes.
May it be coming next week?
He will give next week, not possible, but one not.
Yes.
Yes, sir.
33. This is an appeal against the order of the confiscating authority refusing to refund the property because of the death of the applicant, death of the party who was facing the prosecution. And on the ground, the rejection order is simply on the ground that an appeal is pending. Mere pendency of the appeal will denude the authorized officer to exercise his power. This amounts to abdication of statutory duty, madam.
No, the appeal against the conviction.
Sir, appeal against the confiscation. Sir, there cannot be any conviction because the petitioner died.
He is,
petitioner died.
I was thinking,
So
394.
it stood abated. Trial of the disproportionate case stood abated. Confiscation order was there.
Yes.
This honorable court directed.
I understand. Yes. Yes, sir. Where did they allow the disease? Disease accused.
The present that application made before the learned authorized officer is premature in the sense, my lordship, and there is no illegality and infirmity in the order passed by the authorized officer. Your lordships will find first from the impugned order.
Yes. Which annexure?
My lordship, that is at
Annexure 2, page 14.
Yes.
Page 14, my lordship. My lordship will find this order shall dispose of the petition filed by page 15.
Yes.
Operating.
Yes.
This order shall dispose of the petition filed by the learned advocate for opposite party.
You already tell me what do you want.
My lordship, what has happened, my lordship, in this case, the main accused faced the trial, and during trial he died. And so far as the confiscation proceeding, which was initiated simultaneously, it was finalized by the authorized official. And during lifetime of the main accused who was facing trial, he preferred appeal before this honorable court, and that appeal is pending, still pending for adjudication. And in the meantime, he died. The main accused died. So the trial which was not being completed there was aborted.
So, and he preferred the appeal against the final order of the.
No, see, the problem is, see, the confiscation is contingent upon this.
Yes.
And you are not able to convict him because he died, wrong, right, whatever.
That is not the question here. My lordship, what has happened?
You must be telling one thing, that he should have moved application there in appellate court. Yes.
No. That appeal is pending before your lordships for adjudication.
Yes.
During.
What will you adjudicate if it is the confiscation itself is contingent upon the outcome of the proceedings, trial proceedings?
That is correct. My lordship, what I am saying, my lordship, that appeal, finalization of that appeal will suffice their claim. There will be no problem. But
according to me, that appeal is infructuous.
During
the person died.
During pendency of the appeal arising out of the that confiscation proceeding, when that is pending before this honorable court.
Everything collapsed.
Yes.
Once he died.
Thereafter, they have.
This is under the Special Court Act. This is contingent upon confiscation.
One section you read it.
Yes, read it.
15, section 15,
Special Court Act.
15(6). Page 32, perhaps in that book.
Special Court Act, yes.
Section 15.
15 of
6. Page 32 in my book, but same book.
1 minute.
Same.
I am pulling the same, this book.
32. Page 30.
The author is there, you can't. Author is sitting, author is rightly sitting just beside me.
Other,
he doesn't have any serious objection.
No, he's saying better. No, ମୁଁ କହୁନି ମୋର ଏଥର objection କିଛି ନାହିଁ କିନ୍ତୁ ଗୋଟିଏ କଥା ହେଉଛି କଣ ଏତେ.
Well, I'll stop it here.
56 my lord.
Yes.
Lordship precious time will be saved.
Yes.
The order, my lord. The order of confiscation passed under this section shall, subject to the order passed in appeal. So appeal is pending. When appeal is pending and they are participating.
I'll tell you, this appeal is referred to the conviction appeal.
My lord, I don't
What are you talking?
My lord, what has happened, my lord?
This appeal is, why I'll tell you, the reason is, come to the fundamental principle. First principle is, appeal is a continuation of original proceeding. Therefore, what it says is, if he is convicted and appeal is pending, in that appeal is decided, the confiscation will go on. That is the idea of this provision. But he can't be convicted today because he died.
No, my lord, it is also not on that aspect, my lord. What has happened, that appeal is pending here.
Which appeal? Appeal against the confiscation.
Confiscation is pending here.
Yes.
For application.
He has not been convicted.
No, not.
Had he been convicted and appeal is pending, then you have to wait till the outcome of that appeal.
No, my lord.
Contingent theory, that's the continuation of original proceeding. That's the idea of the provision.
That is true. When that appeal will be decided,
which appeal you are talking?
The appeal against conviction.
No, this provision doesn't say that appeal. It's talking of the appeal having
during pendency of the appeal, which is filed by the accused who.
So what I'll do is I'll pick up the best sentence which you have spoken.
How
in which favor?
What is the illegality? Is there any power lies with the authorized officer to deal with this?
Why to burden courts like this?
No, my lord,
you know the outcome of this.
No, my lord, I don't want to burden this honorable court. What has happened, my lord, during pendency of the appeal, out of a final order of the confiscation, is there any power remains with the authorized officer to deal with same prey that you release the property?
Then what you are trying to tell is, why don't you put it like that? The authorized officer doesn't have the power to review. So the appellate authority could do it. Simply you tell me here that why how do you do that? He says that the authorized officer doesn't have the power to review his own order. He has passed the order, now it is subject matter of appeal. So you go to the appellate court and do whatever you want. And that's what he says. He's going here and there and there. That's what he says. My application under section 96 says, under section 90, the authorized officer is competent to pass an order of release. 19.
Section
Okay.
19.
Yes.
I have moved under section 19.
19, right.
The application has been dealt with under section 19.
19. Okay.
This is an appeal against the order passed in the under section 19.
Yes.
Does 19 say that if the appeal is pending against the confiscation order, he will be denuded of his power?
Yes.
Where is it?
19. Where is 19?
Section 19.
33.
33.
All now
This
appellate court.
This provision is based on the fact that if there is a acquittal, if there is a reversal of the judgment, then confiscated property will be refunded. The same principle applies to the case where there is a death penalty. And the property accumulated in connection with an offense. Offense has not been established because he died.
Read 19.
Yes.
Wait, I'm not able to get the provision. What is there? I got it.
This is the
The confiscation made under section 15 is modified or annulled by the High Court.
High Court.
Yes.
When a person affected is acquitted.
Acquitted. It is not the case of acquittal. It is the abatement. So, and appeal is pending.
Where
Appeal is pending.
it is executed by the special court.
And authorized officer no of the confiscation.
You also see this judgment.
It is not possible for litigation to return the property. Persons are with. Right, yes.
File an objection, let him file objection.
Yes. Section 19.
If in the event of acquittal, it can be dealt with, why not in the case of death?
সেটা কোন বিরাজিন কোন কেস
You give that judgment and then pass the order. You also want to say something? Yes.
So the written note will have-
Written note there, dispute of order. His judgment would have been there.
আমাদের সাইটেশনটা কোন
You exchange this thing.
deal করছি।
No,
He's my friend, I'm just joking, I'll share everything with him.
Not the other party will please. In fact, acquittal, see, in section 19, the expression acquittal which is occurring, the acquittal is equivalent to a position where the accused has died on a matter of choosing.
Conviction.
Here, once he is convicted, decided. But 19 says that acquittal is nothing but in the context of this act, acquittal is even after death.
Conviction precedes acquittal method. So if I cannot.
You have to procure a conviction to sustain the confiscation. You can't procure the conviction in these circumstances. So it is deemed to have been simple.
କିଛି ଅବଜେକ୍ସନ ନାହିଁ ଗୋଟିଏ କଥା ହଉଛି ଆଫ୍ଟର ଫାଇନାଲ ଅର୍ଡର ପାସ୍ଡ ବାଇ ଦି ଅଥରାଇଜ୍ ଅଫିସର which has been challenged before this honorable court.
I'll dispute that. You please help me giving better notes so that.
Refer to that, the authorized officer has dealt with that. So everything is on record.
But give a
Yes.
good note so that I can.
ହାଇକୋର୍ଟର ଅପିଲଟା ପେଣ୍ଡିଂ ଥିଲା ବେଳେ ସିଏ ସେଠି ରିଲିଜ କରିଦେଲେ ଇଟ୍ କ୍ୟାନଟ୍ ବି
Okay, let us. You have to give notice. This is here.
Before. 3 years conviction under section 14.
Lordship, item number 34, wrongly the copy has been served upon the state. It's a
I have
vigilance
not
case.
received any copy, my lord. I may be pardoned.
Copy it is. There is the
Advertently given to it's been possible to me.
Dear mom,
May I pray that your lordship may directly register it to indicate vigilance in the cause list.
Yes. Yes.
And the order
I am praying before his lordship.
the 3 years conviction and fine is there.
3 years conviction.
And similar.
Let it be.
Yes, we let it. Similar order has been done by in the rest of the court.
It is going to tag with that, and Mr. Sanjay Das name should be reflected in the
On
cause
behalf of,
on behalf of the.
I'm on behalf of Mr. Barik.
Yes.
May I pray before your lordship to direct the registry to indicate vigilance in the cause list? Vigilance. Not indicated as vigilance.
Oh, state of Orissa is okay. Vigilance, huh? Vigilance bracket record. Yes.
Obliged, my lord. Free copy be given.
Free copy, okay.
Obliged.
Yes. 35. I don't take fast item. I need some time to get ready. So I'll do the matter from this side. First item, sir. First item is asking time.
He is asking time in criminal division 549. I am in criminal division 575.
What are these matters?
Challenging the order rejecting my application filed under 230.
Application for?
Discharge, not to frame charge.
Okay, there are two matters, huh?
Yeah.
Okay.
One, the first case pertains to the chief engineers who found that committing all this, and second is pertains to the divisional accounts officer.
The second matter you are appearing.
My lord.
Yes, tell me. Let's see. If he has a case on merit, then you obviously have. Otherwise, you don't have.
I am separate petition. Let him.
Separate, no. There is a case
against him.
My lord, he is the person. My lord, this is a case like this.
Is it your case that he has done everything? I am innocent.
No, my lord. The case, my lord.
Then both of you have to argue.
My lord, I am arguing, my lord.
Yes.
It's very safe for him to sell it, Mr. Dawn. It's a safe seller.
Okay.
My lord, case is like this.
Yes.
Because of, my lord, hygienic, shortage of hygienic water in Bhawanipatna, Bhavani district. So government decided to supply chlorinators. It was so urgent, considering the need of the time, the direction was given to the concerned chief engineer.
Yes.
To install ballot chlorinators in different parts. Ballot basic page 77 of my brief.
Yes.
Page 77.
77. Yes. Yes.
After investigating the case, the observation of the investigating officer is in analyzing the evidence on record, both oral and documentary, that is their case, not my case. It has been proved that Prasanta Panigrahi, the chief engineer, initially at the level without taking due care and caution, in violation of the provisions of OPWD code, arbitrarily ordered the executive engineer RWSS division of the state, including the executive engineer Karahanti RWSS division of Bhawanipatna to go for procurement of electrochlorinators for PWS schemes.
77
Yes. And the chief engineer intentionally remained silent as regards the cost of each electrical so and so going
by my lord friends
by the executive engineer. This being a totally new technology going to be adopted in the state of Orissa, he should have in a clear and categorical term pinpointed the cost of each electrochloride chlorinator from the initial stage, taking automatic, taking advantage of say night, taking engineer that is level, manipulated the total tender system by publishing a tender to How many bidders have participated?
Madam?
How many bidders have participated? Two bidders. Yes. Yes. I read it.
Madam. It's a question of involvement of the present petitioner in the case.
You are the chief engineer.
No, madam. The poor madam accountant.
Accountant.
Madam.
A chief engineer, executive engineer have done everything.
Yes. That is the case. My lord.
Who are you? You are executive engineer.
Chief engineer.
Yes. Yes, please.
That was my submission. I
Yes,
appeared.
Mr. Das. Chief engineer, these are all, I'll tell you, these are all technical fees.
Prasanta Panigre. You are appearing in this case is Prasanta Panigre.
I am not appearing for Prasant Panigre.
Then
Then the other case, two cases have been done.
other case is Ramesh Chandra Chaudhary.
Yes, yes.
He is Ramesh Chandra Chaudhary.
Yes, Ramesh Chandra.
His case is bit different in the sense. This is regarding the procurement of some equipment. That is chlorinator.
And I've gone through that base notes. Let me
I'll tell you what is the case. I'll just assist me that.
Well, in fact, he has not placed the materials which are against him, lords.
Who?
I'm sorry, my lord. The materials which indicates the materials connecting the particular accused petitioner Ramesh Chandra one, who has a divisional account officer, my lords, that has not placed for lordship, my lords.
No, the allegation, what is your case is, the chief engineer, these are all the new apparatus to be used in this system. And for the procurement of this system, tender was floated.
Correct.
Technical know-how was with the chief engineer and all executive engineer and all. These people have not, they played, kind of technically they since they know, they try to hide things and floated the tender and manipulation has been done. So therefore, the entire responsibility goes to the chief engineer and executive engineer and down the line all the engineers. What he is trying to say is, I am an accountant. I have nothing to do with the
I'm a financial person. I'm involved in this kind of no. In fact, there are materials which unerringly indicates his complicities, and the materials on records, my lord, which are placed by the opposition lords. This was great suspicion of being a complicity. Lordship put me the question how. Lordship on to page 65 lords.
Whatever his role was shown me.
Exactly, I placed only 3 lines only. And just page 65, 66, and 77. 65, Lordship to 60.
Yes.
65.
65 of which brief you are talking about?
That Ramesh Chandra Chaudhary notes?
Clause of tender, ma'am.
Yes, 65 notes.
Clause of tender.
You also turn to the last serial number 5 and 6. This is the background notes.
Yes.
5 says what the bill is for payment. This pertains to finance the bills for payment were submitted by the agency. The person that was selected notes in that process plot. On 25th March 2008, that is before approval of tender, that is on 26th March 2008. Second, the bill, this is important, the bill submitted by the agency who was selected were passed for payment even before receipt installation of the electrodes violating the condition of the tender. Not here this thing starts, and we gather momentum in the next page 66 notes. 66, I'm placing only the first 2, 3 lines regarding, I'm starting for regarding. Lordship got it notes? Regarding EC for tender, it is to be noted that on the receipt of materials, but retail invoices, bills are received by receipt from the supplier for respective junior engineers. It is the duty of the divisional account officer, that is oblique the petitioner, oblique the accused in this case, to verify whether the materials as per the specification make mention in the tender paper have been received or not. But in this case, the supplier who had mentioned in the tender paper who supplies electrocorrelated so and so, but supplied the processed waters in violation of the tender condition. The stipulation has been absolutely ignored. He is citing the responsibility to verify. And say Ramesh Chandra Chaudhary, the petitioner for this non-report. The divisional officer something like division passed the deal and sent the same to LGB divisions for passing these final orders for payment without verifying the violation of CBA. Accordingly, the orders passed for payment once is liable for the same. And the other important metrics, which indicates his complexity, that is page 77 words.
Which ballot was going through?
No, I'm placing the last paragraph.
Your Lordship got the case having some words.
And there.
Your Lordship turn to his complaint starts from the last paragraph. It starts in the case that committee consisting of Ramesh Chandra Chaudhary, he has placed accused more. This accounts officer, he wasn't committing.
Yes, you are not only involved in the tender process and subsequent judgment.
Reading peaceful instead of going through the petition.
This is not a.
No, this is not a way of argument.
This is.
I was thinking let him complete, Bernard. Let him complete.
Let me please,
I'll continue after lunch. Continue. Huh? Or you want some other time because
he wants time, but
say another 10 years. All three will start.
Fix a date
Monday or Tuesday.
And he adjust it, but keep it at 3 o'clock.
Yes.
So that I can conclude it.
Monday.
No, whenever next week.
Tuesday or Wednesday.
Next week depends.
My learned friend wants
He said Panchanagar item ta BP and CP matter. That is similar issue 62, 64, 65 and 81. Your Lordship has urgent it item 5 to 25th. Let it come along with 25th. It can be hard. And let them come. Let them to that. My non-senior is happy in that case.
Another name of that particular case.
Also similar issue same.
In that case.
no what I because well, let me complete. What I am suggesting, my lord, after going through all the judgments, because I was prepared to argue the case in spite of all problems, my lord, going through the judgments, two things my lord is to decide. One, I have also gone through my lord's judgment, delivered in the month of February, but not been reported. Unfortunately, I see that it is true.
Yes.
But one point is, but with regards to disciplinary proceeding and criminal proceedings, after exoneration in departmental proceeding, whether criminal proceeding is continuable.
Right.
My learned friend has argued a case before Honorable Justice Patnaik, wherein Honorable Court was pleased to, and that is also a default in facts, that in a vigilance case, this is not applicable. Number one. Number two, in some judgment, it says depending upon the facts and circumstances of case. Even my lord has said so.
Yes.
So two things we have to decide. First point is, after due examination,
are you ready to argue the matter today?
right.
I will hear him and so far you are concerned, you argue that day.
I was saying so. I was asking.
My learned senior is ready. I am also ready.
Many matter, 5, 6 matters are there. We will hear it and finish it up.
Decided that will be better.
3:30 today.
Which hour have?
Huh? 3:30 because the other passover matters are there.
So Tuesday 3:30.
Tuesday
Wednesday.
ସେଥିପାଇଁ କହୁଛି ସେ 25 ତାରିଖ ଆସୁ ଏକାଥରେ ସବୁ ସରିବ।
ପଛରେ ମୁଁ କହିବା କଥା ଯେ ସେ ଗୋଟେ ପଏଣ୍ଟ କରିଦେଲା ଆମେ ଯେ for all times to come, because this problem, what I have understood, this problem crops up after my argument before Honorable Chief Justice in Minakatan Pani. It was not there. Nobody in our High Court was raising that point. I raised it for the first time. After a full-length hearing,
everybody was relying upon Radheshyam and all that.
Even not a single judgment of Orissa High Court was there relying Radheshyam Kejriwal or Ashish Randranath. No, not a single judgment was there.
I will take me on 25th. I will hear it.
Because from that case, it started. All the, after it was reported that good many cases have been filed by my friends. And 3 cases were in 2 cases that Minakatan Pani has not been taken note of, even ignored, so to say. And in some cases, Rishabh Kejriwal has been taken note of and Tyagi has been taken note of, but this is Ashish Randranath has been ignored. In
if I have to deal with, I have to deal with all the
island. That I want, and how it has been taken note of by Honorable Chief Justice If there be any conflict, my lord, it should be referred to a division bench and to be settled for all times to come.
Yes, that is a better idea.
Because
Concisely take.
judgments, my lord, even Honorable Justice S.K. Saab passed a judgment, my lord, in the year 2023, relying upon Minakatul Pani, Asu and Rajesh Kejriwal, and allowed the criminal case. Question comes up, it can be allowed in cases investigated by crime branch, CBI or anything. My learned friend says, in vigilance case, this principle should not be taken note of.
We'll see that.
That the logic behind it. Vocal government wants it.
Disposal of very good sentence and for you. Very good sentence and for you 19, right? By the council for the petition further submits that the petitioner was on bail earlier. However, after the graver offences added in the charge sheet, he may have to seek fresh bail. Fresh bail. The liberty granted to the petitioner to apply for fresh bail. If such bail application is moved, same shall be considered in the light of course that Sushila Agarwal judgment. Sushila Agarwal yes.
Judgment.
If Sushila Agarwal judgment is there, you can get it. Yes,
My lord.
yes.
Item 7.
No, please, Your Lordship.
Yes.
Here in this case, there is a tussle between two advocate groups, my lord. Last occasion, Your Lordship directed to file charge sheet. I have filed charge sheet, my lord. Charge sheet submitted 341, 294, 323, 506, 34.
Yes.
Here in this case, my lord, well, the informant who is an advocate and the petitioner also an advocate, my lord. While the bar member doesn't, my lord, he time and again he lost the against the advocates, my lord. Here, who? The who is an advocate? Hemanta Kumar Panda. You are not included. Your Lordship, including my issue is included.
Who advocates this case and counter case, because he will come and again he will say that my case is there, right? His case is
That's true. I will just issue notice, let him come, we will see that both the cases are disposed of. Why in the bar, why should issue notice to Mr. Saul and counsel for the petitioner seeks permission to implead the informant in the present case as a opposite party number.
Let them, Your Lordship, send mediation, my lord, High Court Bar Mediation Center. They will appear and
which bar is this?
Barampur Bar. Ganja, Barampur Bar. 80 years from it, clearly I can settle like you.
also there.
Whatever may be, the bar, they should come here.
Yes,
Issue notice to the informant so and so. Will include the informant as opposite party number 2. Issue notice to the newly implemented opposite party number 2. Mr. Janna waives notice for this state. Then counsel for the petitioner further submits that the case and counter case between the parties. Both the petitioner and the opposite party number 2 are the members of the bar. Due to misunderstanding, the cases have been filed. Therefore, he submits that it would be expedient if the matter is referred to mediation center of High Court. Accordingly, matter is relegated to mediation center. So, see long for the coordinator is directed also. Awaiting mediation report. Leave the matter so and so. In the meantime, proceeding before so and so state.
yes, okay.
11.
So, Matrimalats, last time I was explaining to your lordship the prosecution case. This lady says she has been allegedly raped by the present petitioner, my lords.
Right. Petitioner is agreed by the order dated 16/4/2024 passed by the second additional sessions as Katak, whereby his whereby his application under section 457 CRPC for release of the seized pistol has been rejected. Petitioner is not the accused in the the facts of the present case necessary to decide the page 26 for the facts. 2.2. Again, the petitioner initially applied for application, applied for release of the where is the original order? Where is the original order? This is the revision order.
Yes, your lordship.
Where is the order of the trial court?
Lordship, page 21.
21.
Stick office lordship.
Where is 21? Page 21.
21, your lordship.
You are not able to understand. You moved an application 457.
Yes, Lord.
Which was rejected with the trial court.
Yes, Lord.
You filed revision.
Yes, Lord.
Revision is dismissed. Where is the trial court order? Rejecting your application. You have filed the revision order only.
Yes, your lordship.
Why these petitions are being numbered? I don't understand.
We have not filed.
How these petitions are numbered? Not even filed the revision order. You see, these are the necessary order, it is not there. Now, what is the issue? You should keep it with you. Sure.
Lordship, give me some time, I'll find it.
Call the SR. I'll pass a judicial order now. I will not tolerate like this. How can the petition be registered without the impugn order also? This matter was heard. How many times you know? How many times this matter is heard?
Sure.
You are wasting judicial time unnecessary. I'll impose cost. I'll allow it and impose cost. 5,000 rupees you pay. Okay. Right off. The petitioner had applied for moved an application under section petitioner applied moved an application under section 457 CRPC for release of the pistol which has been seized in connection with the PS case number 69 Badambadi PS case number 69 of 2023 registered under section 25/27/30 of Arms Act. Petitioner is not the accused in the said PS.
Lordship, may I submit a
However,
copy of it?
keep it with you. Do not find what is used. Petitioner is not the accused in the state PS case. However, the principal accused in the state PS case alleged to have taken the pistol, licensed pistol of the present petition. Petitioner moved the application moved by the petitioner has been turned down by the which court I don't know. Impugn order is not there. We have to set. Turned down by Learned Jane FC City Cuttack, by the order dated 22/6/2023, in criminal MC number 52 of 2023. Agreed by the said order, the petitioner moved the revisional court by filing criminal revision number 68 of 2023. The second additional sessions judge Cuttack, by the order dated 16/4/2024, has rejected the application inter alia recording age under 6.429, 6.4 page 29, 6.47, 6.4 and 7 and page 13, 29, 30, page 30. Petitioner being agreed by the aforementioned order, the petitioner has approached this court. Heard Mr. So-and-so, Mr. Das so-and-so for the petitioner and Mr. Nayak for the state. The petitioner contended that he is not the accused in the PS case. He had only given the pistol to seized pistol to one of his friends who appears to have taken the same to Maharashtra party, wherein he was apprehended and the case was registered. He has also filed an affidavit by way of an undertaking, affidavit dated 8/11/2024, inter alia stating as under para 3, 4, 5 and 6. In the aforementioned affidavit, he has given an undertaking that he shall abide by all the conditions to be imposed by the trial court while releasing the pistol, and he has also given undertaking that he would not misuse the pistol in subject. In the event he was found wanting for misusing the pistol, the license may also be cancelled. Taking into consideration the undertaking furnished by the petitioner in the form of an affidavit and the contention raised by him in the petition, I'm inclined to allow the petition. Petition is accordingly directed to apply move a fresh application for the trial court is accordingly directed to release the seized pistol by imposing appropriate conditions in the light of the undertaking furnished by the petitioner before this court, and with all other conditions being fit and proper in the facts of the case. Next order. It is relevant to mention here that the present petition is filed in this court on 18/6/2024. However, the matter was taken up for hearing on many occasions. However, till date, the petitioner has not filed the relevant orders against which relevant orders by which the petitioner agreed. The MP order has the order by which his application under section 457 CRPC has been turned down, has not been filed, much less filing the application and the objection to the application filed by the state. In view of since the petition is filed incompletely, since the incomplete petition is filed and the same is being registered, I'm of the considered view that for the laconic Basically, my lord, the petition is filed, hence he saddled with a cost of rupees 2,000 to be deposited with the High Court Bar Association Welfare Fund. Yes, do it 2,000 rupees. Published. 20.
May I please, your lordship, my lord, here, my lord, I am filed this application for crossing of the FIR registered in the year 2019, my lord, without investigation, my lord, that is pending at the Vigilance Department.
Yes.
What happened here, my lord? In 2015, my lord, a case initiated against the petitioner.
2016.
My lord, the petitioner, my lord, in track case, there the case, my lord,
What happened, Mr. Marana? 2016.
it is 19. This case is 19.
6/9/2019.
My lord.
You must be knowing what is.
My lord, nothing, my lord. What I am saying, my lord, in 2016, a track case initiated. I have filed the application for passing. This honorable court passed the FIR, for the proceeding. They went to Supreme Court. Supreme Court also dismissed the SLP. Thereafter, this case, my lord, knowingly they have done nothing, my lord. Till today, my lord, nothing. And that's why, my lord, means promotion and all of my lord.
He says that you went to Supreme Court, it is dismissed.
In track case, my lord.
This is disproportionate.
Yes, my lord. And because
you don't investigate.
Don't investigate.
I understand it, but what are you doing? You are so serious, you went to Supreme Court, you don't investigate this case.
This thing.
That's right, though, that you are after his life, it's all right, no problem, but why are you not investigating? Why are you not filing charges? This issue notice returnables also, Mr. Marana seeks 1 week time to get instruction regarding the present status of status of investigation in the present case, leaves the matter after 1 week. If you don't want to file, tell I'll proceed. Because 2000 check period is to 1995 to 2016.
That track period, madam. So after this,
what will you get by the time you might have done whatever you're supposed to do?
And because of this,
held up also. Yes.
27.
Hearing, I challenge the order. The petition dated, the order dated 24/8/2024, wherein I had filed a petition in order to issue summons to the Tehsildar Kakatpur, my lords. The same has been rejected. It is at Annexure 2, my lords.
Who are you?
My lords, I am one of the accused. I will, the FIR has been registered against me under sections 13. My lords. 13(1)(b), 13(2) and 7 of the PC Act, my lords. And the allegations of having taken illegal gratification of amounting to rupees 500.
Yes.
That case. Evidence was closed. Your lordship can see unacceptable. The evening order. She got to say record Tahsildar.
Tahsildar or the custodian?
Custodian. So now your lordship can question. On Pelgala, it is said that in the petition filed by the accused on date 27/3/2024, this court had ordered that 24/4/2024 directing the Tahsildar Kakatpur to cause production of the document as certified by the accused. Accordingly, ATM Puri has supplied the proof attested copy of the inquiry report to the secretary to the RDC on the allegation of the accused. Furthermore, Tahsildar Kakatpur, by this letter dated had instructed his employee to produce the original document as listed before this court. But till date, no such document has been issued. On further control correct, it's seen that in the case that one is Sadia case number so and so is very much available in Exhibit 17. The document is already exhibited.
My lords, the next line.
So far as the other documents are concerned, the accused get liberty to produce certified copy of all the photography.
Why don't you apply?
My lords, we had filed a memo before the learned court below regarding stating a list of documents which are required. After that, out of which some of them are already on record. My lords may see.
Some of them you can apply certified copy.
My lords may turn to page 7, my lords. Internal page 2, page 7, Annex to 1. And the third paragraph, it says, having heard from both the sides, peruse the case record and other relevant documents. On perusal of the case record, it is seen that the accused is entangled in the present case for commission of offences under section 13(1)(b), 13(2) and 7 of the PC Act on the allegation of demand of illegal gratification of rupees 500 from the informant in order to supply copy of order of Tehsildar Kakatpur and Sairat News case number 6 of 10. On further perusal of the case record, it is seen that after recording of the statement of the accused under section 313, the case was posted for defense evidence. At the stage of adducing defense evidence, the learned defense counsel has filed a petition seeking to call for the records as per the list which I have provided before the learned court below.
Yes.
The petition.
That's right. The court says that part of the document is available already in exhibit 17.
Which were called by the learned court below through the Tehsildar. They never come on record. Now let's see. On the same paragraph, my lords.
Very good.
My lords. Towards the end, first it was on the third next page, my lords. It is written under the above circumstances. The petition filed by the accused is allowed. Call for the records as per the list. He has called for the record. Thereafter, it is again said that we have also called for the records regarding the departmental proceedings. There, the learned court has observed it is not required. In the next, which is at order dated 24/8/2022, there is we have again filed a petition for summoning the Tehsildar. And what do you see?
Yes, sir. He has not challenged that. He has challenged the hearing order on the construct 2.
My lords, at page 9, when the paragraph starts from.
Where are the original recording? Tell me, it is allowed.
नहीं original record टा already आती है. ये जो document कौन जल्दी और इससे कौन जल्दी available नहीं होते. जल्दी available काम किए लिखूँ कैसे? ठीक है ना? अपने certificate का भी जल्दी document तो लेकर नहीं मना करेंगे.
See, the fact of the matter is, she moved application, it was allowed.
हाँ.
Tehsildar was summoned. He gave photocopies. Original is not given.
Summoned, Tehsildar is not summoned.
Document कौन जल्दी Swayat record टा that is available already exhibited. And बर्तमान से कौन जल्दी देखो अन्य जो और किसी डॉक्यूमेंट जो कौन से जो डिपार्टमेंट प्रोसीडिंग का सो they can apply for certificate and that is not relevant for the purpose of
That is their outlook. In the defense they want. What stops you to get certificate copy? Tell me.
The copies are not available, my lords. Petition for summoning the Tehsildar what is the documents which are already on record, which was Sibo is placing, that has to be also if the Tehsildar is not called for
Exhibit 17.
that is the objection for which requesting the summons to the Tehsildar.
You said Tehsildar or the custodian of record.
Yes, my lords.
A custodian of record has been summoned. But he has filed the documents already, photocopy of documents.
But summons have not been issued.
So the summons not required.
None of the documents have not been placed on record or not available. If the which are already on record.
You are not able to understand what I am saying. You want the Tehsildar or the document?
Yes, my lords.
What do you want?
Tehsildar.
Why to satisfy your ego?
No, my lords.
Tehsildar has to come with the documents. That is what you have said. Summon the Tehsildar or the custodian of the document along with the document. The documents are already there. The court says that it is already there at exhibit 70. And the remaining documents which are not there, liberty is granted to you to obtain certificate copy. And I can very well say that till the certificate copy is made available, court should hold hand. That much I can do.
At page.
Why should we give? Tehsildar should come. Tehsildar is only to produce the document.
Tehsildar or the custodian of the record in Sairat case. We are not.
You are interested in the document, not Tehsildar's, the document which are in possession of the Tehsildar, those documents you are interested in. You find some defense in that document. Right? The documents are, the document exhibit 17, just see exhibit 17. Where is exhibit 17? Show me. Where is your list of documents? You show me and show me, give it 70. Let me see myself. You don't file those things. Your list of document is not there. He says that documents are already there on record. Where is your list of document?
Let me give me.
He says that documents are already there on record. Unless you show me the documents, if this document is not there, that document is not there, how will I come to know? You will keep on saying that documents are not there, he will keep on saying that documents are there. Who will decide whether documents are there or not? See, these are the things it can't be inferred or, unless everything is there on record, how can you, how will you decide these kind of cases? The problem is if people don't file the relevant documents, casually you file the petitions.
My lord,
You need documents. You don't know which documents. Show me the document list.
Page 7, my lord.
Yes, I'm there at 7.
My lord, the line starts further on 12/4/2024. London Defence Council has filed a memo stating that the document with serial number 9 is in custody of the revenue.
What is that document serial number 9? I want to know. What is that serial number 9? Where is that memo?
1 week's time I'll file the memo.
That's the whole problem. You start arguing as if you place these things on record. This is completely incomplete petition. Right on request, December last. It is applying. Yes.
31. There is a high on record.
No, nothing. I will not. It's incomplete petition. I will not pass any of it. You do it so casually. Why should you're entitled for anything?
Yes, I'll this application for quashing my lord on the ground of compromise, my lord.
Offense?
Offense 376, initially 366, charge sheet submitted, my lord.
Where is the charge sheet?
Charge sheet since long, my lord, showing as absconder, the petitioner.
6 FOCSO.
Aye.
No, yesterday there is a judgment of Supreme Court. You take it up. Pick it up. Now there is a complete.
Now they are married.
What is the implication of that judgment? You have to see it. It can't be done now. I was relying on my judgment. I was doing it.
Yes.
Now there is a Supreme Court judgment. They say no.
Against the judgment.
You can't do it. No, you can't do it all on the ground of compromise once there is a POCSO. Even if you are married, whatever. What to do? To see that judgment and come, simply urgent. Take the power. Yes, next.
Power and affidavit.
Both are
present in total.
What to do, sir?
That will be recorded and call this matter. They have present in court.
Let them. I don't know whether I can pass it or not. I don't know. Just see the judgment. Yes.
36.
Affidavit.
So lordship, affidavit be kept on record. Yes. Okay, they did.
Affidavit everything will take on record. Thank you for file because paperless. Lordship can document. We are very likely.
ठीक होता है.
File it.
Yes.
Yes.
36.
There is a matter, madam.
Yes.
Page 10. Most of us.
NW issued on
18/8/2021.
18. Bail.
Bail on 16/2/2001.
16/2/2001. Whenever he says, you have to hear it. I will not hear and convey to you. 500, 200, 30th November, yes.
37.
Belgium medal the petition earlier on bail 5/5/2013. Thereafter individual issued on 7/3/2020. 2020. Yes, sir. 1000. Obliged.
38. 38 my lord, this is a Belgium matter my lord.
NBW report 7 on 2019 my lord.
You are in bail.
Yes, my lord. There is 18 to 41 comply my lord.
1,000. The two of you are there. Two. 1,000. Yes.
Belgium matter, individual record 3724. Annex 2 plus 15.
Yes.
Earlier on bail my lord, 28,520.
500. Yes.
Lordship, not trying to create an impediment, my lord. No, page 15, it will be seen.
15.
In my brief, Lordship, it's not a certified copy of the NBW. Just bringing it to the kind notice of the Lordship.
Certified copy of the impugn order.
Certified copy of the NBW is not there with me. It's just a general copy that has been provided.
It's all right.
Lordship.
You should have moved an application for exemption anyway. Yes.
40.
40 also. NBW issued on 11/8/2023 my lord. And relevant bail my lord 12/5/16 my lord.
12/5/16.
16.
Okay.
There were
500.
500.
41.
May I please, Your Lordship? My Lord, order of NBW issued on 24/4/2024.
24/4/2000. Yes. Bail.
Bail, my Lord, the bail or date of trial court I am not having right now, but as per the order of this Honorable Court by 1/12/2022, they had surrendered.
1/12/2022. Bail granted. ABPL number 14350 of 2022. Okay.
So bail date has not been taken in the aberment.
Huh?
No bail date has been provided in the aberment.
There is anticipatory bail. Yes. Additional got anticipatory bail. Why it's also ABP also like it. Yes.
56 personal appeals to the compromise.
56? Yes.
56. Yes. My lord, here, and for
This is valid.
my lord, they are in DC cabin, if your lordship of permit.
Now, what is this matter?
Here, I am seeking quashment of the entire proceeding on the ground that the petitioner and the
Averment also my lord.
Just check it up. Yes. Next.
My lord, as one of the offenses so it is a second round journey. So if my lord
Let the
so
yes.
notice might not be required.
376 3.
376 2N is there and 6 of POXO is there. So my
Who is the informant?
informant is the victim.
Why to complicate? You complicate. One opposition is already there. You are inviting another opposition.
No matter.
Yes.
Because my lord, I submitted fairly because certain courts my lord notice is being issued. So I will see before your
You
lord.
are entitled and can do it. Yes.
Grateful my lord.
43. Yes, sir.
The petition corpus, madam, 6/2/2024.
Custody since
6/2/2024, madam.
6/2.
71,85,000.
Sorry.
Hitting of 71,85,000. He is also criminal activity. So I have to take CD matter.
Corpus, please.
44.
May I please, your lordship. The present petitioner is in judicial custody since 1st May 2024, my lord. Your lordship, as per the complainant allegation, my lord, the occurrence date is 3 April 2024.
Yes.
But the victim, the complainant, lodged the FIR on 29 April 2024, my lord. The 164 statement starts from page number 63 and 64. May I, your lordship, can glance to 64.
Yes.
May I read, your lordship?
Yes, Mr. Jana, ready?
64.
Yes.
May I read, your lordship?
Yes.
Page number 64. ये नंबर 7 नंबर ये रिपोर्ट से दिन पांचारू बाहर को जाइथिली से टिके अंधार थिबारु मु जानि परली नि से कोर्ट को आसी मो पछपटु छिडा होई मो सहित सेठारे ठेली दला
मु तळे पडगली
तापरे से मो ऊपरे
was examined as PW
who in his testimony has stated as under page 67. Pura डाल दो 67, page 67. Mr. Sahu also taken me to the medical evidence, which is placed on record. The medical evidence reveals, page 40, na? Where is that? Page 40. The removal of the medical evidence reveals that the where is that 40 na? Page 40 reveals that the victim the victim had lastly had intercourse with her husband 2 days after the incident. So therefore the conclusive medical evidence could not be could not come to fore. Mr. General and Counsel for the state submits that the allegation against the petitioner made by the prosecutrix are very specific, and the prosecutrix has not yet been examined. Therefore, he opposes the bail. Petitioner is in custody since 1/5/2024. Regarding head to the testimony of the sole eyewitness to the incident, and on the basis of the medical evidence brought on record, you have not read the main part of the medical report.
Well, beg pardon, Your Lordship, I am reading.
5. 5 says no forcible sexual intercourse sign. That you have not read. Just
because, my lord, after 26 days.
That is the main thing, Your Lord. There is a case of rape, right? No will for your medical level. Page 40, last to the 5 and 6. 40, 5 and 6. Yes. 5 and 6. Granted bail. Yes. So,
Great.
45.
Cancellation of bail, my lord. Notice was issued and he appeared.
People are struggling for bail, you are asking for cancellation. Why?
Not avoided, Your Lordship. Bail was granted by the order dated 1/3/2024, annexed to page 16. Okay. Hiding a job, my lord, he taken 3,84,000.
Right. He will pay the trial.
It's a bank transaction. Your Lordship, my lord, pays. Your Lordship directed him to pay, my lord, on instruction 3,84,17, my lord, annual grants.
Yes.
He returned 1 lakh within 15 days, and the rest of the amount will pay 1 lakh. Correct here, my lord. From counsel for the petitioner submits that he would pay all the amount to the informant on instruction basis, and to begin with, he would pay a sum of rupees 1 lakh. 1 lakh you got, no? No, my lord. Totally not paid. Not abated this honorable court's order. Totally, my lord. And the amount paid
issue notice.
He appearing, my lord. Your Lordship issued notice. He appeared.
Who is appearing?
I am appearing. We have to monitor sound.
You have given undertaking to this court.
Take instruction, kindly taken on the matter next week.
Pay 1 lakh rupees at least.
I'll take it.
And try to pay the other rest of the amount. What is the total amount is? 3 lakhs only.
3,84,000.
84,000. There is a condition. You have not complied. I will not cancel the bail, but you have to pay it. Okay. Issue notice. Counsel for the opposite party. Number 2, no?
Yes, ma'am.
Opposite party number 2 seeks an adjournment to get instruction from his client regarding the compliance of the condition imposed by this court while granting bail by its order dated 1/3/2024. Release the matter after 3 weeks. Yes.
46.
Six, my lord. 6, my lord. Here is a case here. This honorable court has issued some notice to the victim.
Services. Not sufficient.
And she would advocate general office request for them to engage a lawyer. So I place some other day, and he has sent the buckler now. So can we, because he is the informant, can we time to discuss this matter? Another day,
You will engage someone or what?
नहीं ये जो ये इंफॉर्मर से चाइल्ड वेलफेयर officer. He has sent a letter to the Advocate General Office to engage a lawyer from the penal.
Despite service on opposite party number 2 is awaited, Mr. Janna and then counsel for the state submits that the child welfare officer has written a letter to the office of Advocate General for engaging a panel counsel, hence it's all right, panel counsel, hence he seeks an adjournment. This is the matter after 2 weeks. Yes. Entry order is there? Already. Where is that entry order to continue? Yes.
48. 48, may I please, on behalf of Mr. Raj Mahanti, urgent to next week. She is engaged with the Jira the ring ceremony next date.
There is a function in the family of the counsel for the petitioner, hence he seeks an adjournment in the interest of justice at the end of December last. Yes.
49.
Ah. 29, 14, yes.
50.
You clarify that. 50, yes.
50, 51 and 52. Same matter. And last occasion I have submitted that our Honorable Justice A.K. Mahapatra has passed an order, set aside the order of the Honorable Appellate Court to Kendrapada in the NIT case.
Another case, my lord, but I am appealing for the opposite party, my lord, in all the cases, my lord.
Apex Court squarely, the Honorable Justice A.K. Mahapatra has passed order, set aside the order of the Planning Court below and directed to file petition for grant of exemption. Accordingly, that petitioner filed a petition before the Planning Court below, and that petition also allowed, exemption also allowed before the Planning Appellate Court below. And in this case also my case also.
Where is that order?
Pending before that Planning Court below.
My lord, here is a case, my lord, 138 in Act. I am the, my lord, complainant, my lord, that initially this case was started, my lord, in the year 2019. And my lord, that cause of actions, my lord, arose that on 13/8/2019, and my lord, 1cc was filed on 24/8/2019. Thereafter, my lord, charge was framed, and thereafter, finally, this order was passed, my lord, on.
What do you want to say?
That thereafter, my lord, he preferred an appeal. After conviction, my lord, he preferred an appeal before the London District and Session Judge, Kendrapada. And my lord, which is annexed as Annexure 1.
Yes.
That case 12, my lord, that order portions, he has annexed that the decisions which has already been cited by my lord and my lord senior counsel, my lord, that decisions has already been there in appeal, that the Supreme Court judgment, and after perusing of the Supreme Court judges, that the Honorable Justice, my lord, Honorable Justice A.K. Mahapatra was passed the order. That order has already been cited in appeal, my lord.
What is this?
That the Lorraine District and Session Judge was pleased to direct this the accused part, my lord, 148 to 20%, my lord, but he did not pay till date.
How many cases are there?
3 cases, my lord. He did not pay till date, my lord. Thereafter, challenging that order passed by the Lorraine Additional District and Session Judge, he has filed this application.
Where is Justice Mahapatra's judgment?
No, I have supplied me. I have already supplied.
Show me.
My humble submission is.
Show me that order if you.
And same putting my.
Since 2019, my lord, he has not paid me the.
You are already, sir, you have to pay.
Single try. Instead of the all of them pay. Appellate for
20% direction.
Yes, my lord. That is the statutory provision. You have to pay.
Only
since 2019 to 2024, only technical ground, my lord, they have wanted to avoid for payment. Instead of the order by the Lord Estudiant as well as the appellate forum, till date he has not paid a single fine to me. And technically he is playing, my lord, by saying so and so. Has to complete the order of the appellate forum and then the original court also. The
Jumbo Bhandari.
Jumbo Bhandari, my lord, also dealt with in the case, my lord, kind of a glance to this, page 14 of the brief. That Jumbo Bhandari has already been dealt with in the appellate judgment, my lord. In criminal appeal number 5 of 2024, it has already been dealt with. That it was passed on 28 to 2024. Yes,
already considered.
Yes, my lord.
In the Justice Mahapatra's judgment, Judge is not considered. So therefore, they say that it was mandatory or direct rule. The court set aside and send it back to decide the application on the basis of Jumbo Bhandari in your case has already been considered.
Yes, my lord.
What can I do? Okay.
But
You are not covered by Justice Mahapatra's judgment. You deposit.
Yes, my lord.
if you
I can only say, I can only tell, I have been doing consistently in all matter. Instead of 20%, you deposit 10% and apply to the trial court for variation.
But if we analyze the judgment of the Honorable Supreme Court,
I have read it.
my case comes under exceptional category.
No, what exceptional? You have been convicted.
Exceptional.
That presumption also goes.
How I am coming under the exceptional category, my lord, in I can have a glance to my petition, para 7, page 6.
You tell me, I have.
The complainant has deposited the check on 31 May 2019, and it was got dishonored on 1st June 2019. And thereafter, he has not served the lab notice to the.
Thereafter, he told me that please wait, and in good faith, my lord, I will put some time.
See, these are on merits, I will learn.
My lord, in good faith, I told him that you deposit again, but kindly have a glance to page 45, running page 45.
Check is yours, the liability is yours, you have to pay. But since 2019, you are playing hide and seek role.
Please bear with me. My lord,
Give me
kindly.
that. Yes, Justice Mahapatra.
That's it, that Jumbo Bhandari case, my lord, citing the Jumbo Bhandari case, that which order has already been passed. That order dated, my lord, 1/7/2024.
My lord, the Honorable Justice A.K. Mahapatra has passed, set aside the order.
Citing that Jumbo Bhandari case, paragraph 7.
Yes.
Kind of a glance to this, the paragraph 7, that Jumbo Bhandari case referring to order. And it has already been dealt with.
Justice A.K. Mahapatra.
It has already been dealt with. 5 new things will be added.
My humble submission.
पूरा watch करके ना दिखाओ ये पूरा authority जाओ 84 से जो सटा
10% you deposit, rest 10% you can move on.
It is a case of
No, 10% you deposit.
it is a case of person, my lord.
Either you deposit 10% or I dismiss. It is 138 case, long pending, and you have to already convicted. 10% you deposit and rest 10% you can move on.
My humble submission on same footing as the decided that
I'm not with you, unfortunately. What to do? Because you are not falling under any category. No, you are not. Then all 138 case where there is a conviction, everybody will fall. Then the statutory provision which is it was particularly brought in the statute book only to take care of this situation. And just see the plight of the complainant. He has been fighting it since 2019, my lord.
But it is
After securing conviction, 20% also you won't give.
it is not a
That
case.
is the
It is a
statutory
case of
provision.
person, my lord.
Petitioner is agreed by the order dated 20 to 2024, whereby the learned Sessions Court.
No, Justice A.K. Mahapatra has passed several orders.
Sessions Kendrapara. Chandrapura, by the order dated 28/2/2024 in criminal appeal number 5 of 2024 has directed the petitioner to deposit 20% of the compensation amount compensation amount by admitting the appeal. Next one, petitioner has been convicted by the Court of SCGM Ketrapura in ICC case number 259 of 2019 under section 138 of NI Act. Against the said order of conviction, judgment of conviction and order of sentence, petitioner preferred the appeal being criminal appeal number 5 of 2024 before the Court of Sessions Kendrapura. The by impugn order, the appellate court directed the petitioner to pay 20% of the compensation amount, to deposit 20% of compensation amount within the stipulated time frame. And counsel for the petitioner, by relying upon the order dated 1/7/2024 passed by the coordinate bench in criminal MC number 2260 of 2024, submitted, and that the coordinate bench in the similar circumstances has set aside the order of the appellate court directing the convicted petitioner in that case to deposit 20% of compensation amount only on the ground that the trial court has not only on the ground that the appellate court has had not considered the judgment of the Honorable Supreme Court in the matter of Jambu Bharati versus State of MP State Industrial Development Corporation in criminal appeal number 2741 of 2023. I have perused the order dated 1/7/2024 passed by the coordinate bench. The coordinate bench did by relying upon Jambu Bharati Supra has stated that the direction contemplated the statutory provision contained under section 148 NI Act is not mandatory, it is direct in nature. Therefore, while setting aside the order of direction for depositing 20% of compensation amount, the court relegated the petitioner convicted to the appellate court to move a fresh application. I have perused the impugn order in the instant case. The appellate court has meticulously dealt with the provisions of law and the judgment of the Honorable Supreme Court in Jambu Bharati Supra. I find no reason to disagree with the order passed by the Lieutenant Sessions in the instant case. However, taking into consideration the financial health of the convicted petitioner, I am of the considered view that the petitioner should to deposit 10% of the compensation amount to begin with, and move appropriate application before the appellate court for variation of the impugn order insofar as the remaining 10% of compensation amount are directed to be deposited by him. With this observation, the petition is partially allowed. All the minutes. All 3 minutes. All the 3 minutes.
53, my lord. We have already completed. Hello. Annexure 1 and 3 certified copy we have filed because that Annexure 1 and 3 we pray for passing of the same. So office has to verify that no other defects are there, my lord.
Yeah, what is this case though? Let us-
Yes, my lord, I am coming to this. My lord, this is a vigilance case. So far as Annexure 1 is concerned, that is FIR in 1999. In 2000, my lord, FRT has been filed. Annexure 2, my lord. Then 2013, my lord, cognizance taken. And 2024 charge has been framed, my lord. And so far as this petition is concerned, my lord, I am coming to, my lord, 16,000 टंका मु खाई जाइछि बोली that is the allegation. Your lordship may see that. Page 45, Annexure 10. As on date, that amount has not been sanctioned. Your lordship have a glance at the government report. Then what remains, my lord? Page 45, my lord. Annexure 10.
Yes.
Lordship may see. Not yet released. Against me, that allegation, that 16,000 something else, that has not yet been released. That is the report of the government, my lord. Subsidy. Lordship have a glance to that.
Yes.
Therefore, applicant number such and such, not yet released. The court has also no खाई ले पैसा.
Where are you living? Not at release.
Page 45, Annexure 10.
Yes, and there,
My lord.
not at release, where is that?
Subsidy not released, my lord, release in favor of, that is first column number 1.
What is your name?
Not yet released. Subsidy not released, your lordship may see. And other 2 cases, subsidy release, that I am not concerned with that cases, my lord.
But not release in the column.
Yes, yes.
What is your name?
25 वर्ष पास हो गला.
What is your name?
My
Name
lord,
is
Ashutosh Behra, my lord, Ashutosh Behra.
you are
My lord,
Ashutosh Behra. Ashutosh Behra.
my lord.
You are Ashutosh Behra. Yes.
Okay, inspector, my duty is just to see बोलता खाली इंसर्ट हबो सेतिक मोर देखियो दायित्व सब्सिडी दबा लोक अलगा
Come to page 45, Annexure 10.
Yes, my lord. The district agriculture officer.
This is regarding some other Behra. What is this name?
My
Name in first column.
I am concerned with this borewell. It was favor of my lord Srimati Parvati Behra.
You are Ashutosh Behra.
I am Ashutosh Behra. I am concerned with this borewell, which was sanctioned in name of Parvati Behra. Your lordship may see the affair. My lord, yes, my lord. Come to the affair, my lord.
Yes.
Your lordship may see. Page 13. Nursimha Behra, Ashutosh Behra, myself is the accused. Then other officers are there. Parvati Behra is not the accused, my lord. He is the beneficiary. Because subsidy has not been sanctioned.
I understand, sir. Only Parvati Behra, or you have given to someone else also?
I am concerned with the Parvati Behra. That
how will I know? How will I know that?
Yes, I will explain, my lord. That is there.
Tell me that.
Yes, my lord. Lordship may see. This is the affair, my lord. Thereafter, your lordship may see the final report, my lord. FRT, insufficient of evidence. Annexure 2, my lord.
Yes.
May I read that FRT, my lord?
Yes.
Yes. Page 21, my lord.
Yes, I am there.
My lord, 99 FR was lost. 2000.
I understand everything you just told me, that the subsidy which you have sanctioned in favor of Behra is not released, that is one thing. But the allegation is only against you.
Parvati Behra is not the accused also. So far as FR is concerned, Parvati Behra is not an accused.
And you are not coming to the point.
But
He has 2 points. If I understood what he is trying to say is 2099 FIR, 2013 charge sheet, and
2000 charge sheet.
now after 2 decades you have framed the charge. One thing. Second is he says that the allegation against him is he has sanctioned the subsidy to Parvati Behra, which has not been released.
Whatever remains, the Asutosh Behra and contractor Subrat Naik
Hmm.
prepared the false documents and recommended to sanction the subsidy. But before processing,
Subsidy to whom? Parvati.
before processing, vigilance inquiry started for which the subsidy could not be released. So the offences are 409, 406, 468, 471, 420, 123, everything is there. So preparation of false document is there and CI prepared the false document. So
Who is prepared?
this petitioner.
Parvati Bera is the beneficiary.
Beneficiary.
Why have you not made her as a party?
No, he has not getting benefit. What has benefit?
She is the person who is.
Says the contractor and the Asutosh Behra.
All this thing happened because the investigation took 20 years.
That our investigation we have done the panel report.
You explain the delay, otherwise I'll quash it. This is a useless exercise. He will be acquitted. You are burdening, you are unnecessary burdening trial court.
What I suggest, since trial is on, trial is in the expected space, and some few witnesses are there. Your lordship may direct to dispose of conclude the trial within a month. Otherwise,
How many witnesses you have cited?
हमें final report दे दो हम 2000 में से. It was not accepted. Court took cognizance.
Unnecessary.
आपने sanction by किया. हमें we took sanction. Thereafter, the product of cognizance.
Unnecessary.
Item 8, unnecessary, my lord to clarify, the lordship may have a glance to 41 unnecessary. My lord, joint inquiry report, my lord, I am coming to that.
I will target to be trial for 3 months.
My lord.
3 months target.
Hujur, do it target hai my lord has given twice 6 months. That has not been carried out. That is there. Lordship may keep it on 11 so that I have some personal difficulty. I have come to here. Lordship may keep it on 11 so that I can satisfy your lordship. And similar matter has been quashed by the 2007 matter.
When you appear in VC, you are more louder, so I can hear better.
Your lordship.
You show me to others and pass.
Your lordship may see. And one case, the coordinated matter has passed in 2007 matter. This is 99 matter. 2007, my Mr. Maharana was the party to that case, my lord. That has been.
What I'll do is, I understand. What I'll do is, 1 minute. What I'll do is, I'll call for a report from the trial court. Okay? That's why I'll target it.
Lordship has called for the trial, my lord, twice in writ application, 6 months has been granted. Nothing has been come up, my lord. So, Lordship keep it on 11 so that I because annex 8.
Keeping in view the checkered history of the present case and the fact that the present case was registered way back in 1999, I am of the considered view, 99, a report may be called from the trial court regarding the status of the trial, during the status of the trial. On the next date appearing, release the matter on 18th or 19th? 19th.
18th, Hajun ko bari ho 18th. Monday, Wednesday, Friday.
19th.
Obligate.
Right.
Similar coordinate bench has passed by the similar.
Yes. Yes. I have called for a report, let us see. Yes. How many matters are there? 53? You dispose it of all by quashing proceeding. 99 days you won't get anything out of it. Yes.
54.
May I please, Lordship? Lordship, here on the basis of compromise between the parties, I am seeking quashment of the entire proceeding. It's a 498 matter, my lords.
In this case, my lord, I am appearing for the opposite party number 2. Mr. Ashok Das and his associates has filed the Bhakulatna since 10 days back. Name of Mr.
Call them.
Next week also indicating the name.
Yes, call them. 498, call them. Yes.
55.
Yes.
A notice was issued.
Service not sufficient. Service not sufficient. First steps to be taken for the purpose of serving opposite party number 2. Please the matter, yes. 56.
Entry order is there. That entry order is there.
Entry mode to continue.
57.
I have a request. Item number 80 was fixed at 3 o'clock.
Then I just run through.
I was just reminding you.
See, time fixing, this is the problem. Once you fix, you can't take out the matter at that time. That's the problem. Anyway, we'll see. Yes.
Now, in this case, the written note of argument has already been filed. The list of citations are also filed, my lord.
But now there is a change of guard. That's the problem. Madam, have you seen it?
No, sir.
See, I will accommodate only this week.
Only see.
I have decided for 15 days I'll accommodate. After 15 days, I'm not going to accommodate.
The issue involved, my lord, in this case is res integra. It has been decided by this honorable court.
No more res integra for you, but res integra.
It will not take
Madam,
time.
just take the file with the note and all.
It's there.
Get ready. Get ready. If you want to file written submission, do it.
Documents are not visible.
That I can't help you to ask him. Which document you are talking about?
All the matter has been heard. If your lordship sees the order sheet, my lord, it has been heard several times, and no such objection was raised ever.
But she can't see it. Na? The other lawyer might have seen it. His eyesight is better. Her eyesight is not better.
Your lordship eyesight is also better, man. So it will make no difference.
Give possible.
I'll also like a copy. But it is there in the
List it, and the entry want to continue. It's made clear that no further adjournment shall be granted in this.
But not with regard to the petitioner. Petitioner is ready today, my lord.
Yes, on the request of counsel for the state, the matter is adjourned. Entry want to continue. It is made clear that no further adjournment shall be granted on the next date of hearing. Yes.
58.
58. Non-appeals for the petitioner. In the interest of justice, adjourn the matter to serve justice and entry mode to continue. It is made clear that no further adjournment shall be granted. Yes.
59.
It's coming forward. Yes. What is this matter?
Second also directed to remain present the informant victim your also by the word of 12. That is the 21 days and 24 years.
21?
10, 2020.
No, which item?
60 or.
Huh? 59.
59.
Yes.
Yes, 59. 59.
No, this is Sarat Kumar Sahu.
Yes, sir.
Huh?
Yes, sir.
21.
Yes.
No, 21 is only request reach the matter on sir.
My auditor is expecting that 21
And thereafter nobody appears. It is made clear that no further adjournment shall be granted. Interim order passed on shall continue till next date of hearing. Nobody comes. Right. On 28/10/2024, the matter was taken up and the following order was passed. None appears for the petitioner today. In view thereof, the interim order passed on 19/9/2016 by this court is vacated. Interim order is vacated. Take interim order, don't come. Yes. Next, 60.
60. 61.
This matter, if your lordship remembers, was argued at length before your lordship minutes. Washing cognizance taken under
My lord, section 376 to A3. Here. My lord. For that. I've already given the, my lords.
The time giving is very difficult. What is your matter, by the way?
My lord, I have challenged the discharge petition has been dismissed on the ground previously in a CRLMC. This honorable court has appreciated everything and given on.
Do you have an interim order in your favor?
No, my
How did they give it? Saturday you come then 7th.
Saturday 30th.
7th.
7 December.
So that at least the matter can be.
My lord, 7th lower court है 7th actually. So prior to that.
6th. No, 5th, 6th. 5th or 6th.
I will participate. Item 75, both have got marriage. Your Lordship directed to appear in person today. They have not get that ticket. They were serving at Gujarat. 30th it will suffice entire thing because they have to open 30th. And interim order is there completely. And I pray for your Lordship, another 63 can be disposed of because your Lordship is going to wake up the Monday.
The remaining matter can be.
Item number.
Last time also nobody came.
Because they are not coming for compromise. Despite the several attempts, they are not.
You are for opposite party.
I am for the petitioner.
What do you want?
Let it be on procedural endorsement issue, and then come and matter we can revive. We have that liberty.
What do you want? Sir, I give you liberty to
move again, then if they are compromised with the party, that.
See, you said that they have settled the dispute. That is the reason.
They are not turning up that whole problem. Despite what several attempts, but they are not turning up.
I have dismissed in default. Once they come and move an application and restaurant, you allow you?
You say that.
Dismiss in default could you?
Yes.
And once they come, move an application and restaurant, allow? Simple.
My lord, item 70 can be disposed of, your Lordship.
Same.
My lord. Item 70, the brother-in-law is the petitioner in domestic violence case. He has been made a party. The difficulty is that in 498, husband has been acquitted, divorce has been allowed. So you must be absconding or something. No, my lord. I am there. I was there. Now my learned counsel for the complainant has also appeared. The interim maintenance what has been ordered to the wife has been set aside by this honorable court with a direction to hear it again. And it has been stored in this. You are not opposing.
Yes, man. Opposite party.
Opposite. Are you opposing? No. My prayer is that, your Lordship, let the brother be deleted from the domestic violence case, brother-in-law. Let it proceed against the husband and it may be targeted so that her maintenance can be decided. That is what we have understood. But your Lordship,
target, how can we target it? You are not a party.
I was a party.
You are not going out.
That your Lordship may consider.
And the other people, those who are the party,
that is his prayer.
Suppose and allow it. It will be like there is no opposition.
That's the only thing I can. No, your Lordship, on the basis of the divorce and acquittal in 498 case, your Lordship delete the name of brother-in-law because brother-in-law is not a party in criminal case. Criminal case is husband acquitted, divorce allowed.
Put it in Monday, we'll see. 1 minute. Senior report.
Item number 74, I was called prayer. Only improve order to continue. No. Let it come on Monday.
Taking up the interim order will continue.
नहीं नहीं कथा जरा बेंगलुरु जजमेंट में जजमेंट स्टे दे हैव फाइल्ड द पिटिशन बिकॉज़ इन 1/7/2024 रू दे आर एंटरिंग द इंटरमीडिएशन ठीक थिला बट सो माय नॉलेज इज आई एम नॉट टेकिंग इट अप विथ स्पीच कैन यू स्पीक एनी टाइम बट द इंटरमीडिएट विल कंटिन्यू आई एम नॉट टेकिंग अप विथ द इंटरमीडिएट ओके लॉर्डशिप continue it is still this day no you continue no no separate nahi intermediate I'm not saying anything madam it will be listed on Monday Monday asle more problem nahi Monday asle
Item 68 that supplemented list item 34 in which copy was not solved. I found that this matter is liable to be listed along with 3 other appeals which your lordship have already admitted.
give the number
Yes, I am giving the number, so let it,
give the number
हजार एक है, हजार बयासी, give it.
Item 68, my lord.
71, my lord.
I told you when the seniors are there first let them
Item 71, my lord, very small thing is to be decided whether in that case it has been submitted or not. 71 has to say.
71 more आ गया.
71
No, 67, my lord, general number of 67.
yes
And in that case, as your honor will kindly remember, the affair was lodged in the year 1930.
what instruction
For the instructions, acid has already been filed since 2000, December 2020.
20?
Please.
so I dispose it up with the liberty to
renew my
I am responsible for the petitioners. I mean, in this petition is seeking direction for. Petitioner is seeking quashing of the entire criminal prosecution initiated against him in Vigilance GR case number 32 of 2013 on the ground that although the FIR was registered in 2013, but the Vigilance department has not filed charge sheet as yet. Pursuant to the direction of this court dated 22/4/2024, Mr. Maharana, the counsel for the Vigilance, submits that the charge sheet has already filed.
Case number 37, dated 19/12/2020.
19/12/2020. In view of the aforementioned statement, Mr. Patnaik, counsel for the petitioner, seeks to withdraw this petition with the liberty to resort to the remedy available to him under law at the appropriate stage. With this liberty, the petition
Item 68, my lord.
77, 78.
sorry. If I am not taking up, it will be taken up one day. Yes, yes. Huh?
77, 78 Monday.
If I am not taking up, it will come. Don't worry. Yes, now.
Yes, my lord. 71 item. Yesterday matter was listed that 311 petition was rejected and I have filed that POCSO case. I have filed for recalling of for quashing of that 311 petition. Your lordship has directed me to file affidavit from the informant side. Informant is filing affidavit. New development that now the informant is staying with her the present accused person in her in-laws house and they have blazed with it.
What do you want? You are arguing entirely.
I want my lord, my kindly, I filed affidavit. Affidavit has been, I am filing.
Because you will file online. You file it, I'll take it up Tuesday.
Because matter was kept to, on trial court, matter was kept to 12, my lord, for accused statement. If accused statement will be, then
what will happen? Nothing. Accused statement is not the final. I can then also I can allow. What is the problem? At 311 I can allow that's also.
Yes, my lord. Thank you. My Monday.
Tuesday. Yes.
Item 60.
I filed the affidavit now.
Item 68.
File the
Item 68. On request of Mukta, kindly take no next any
68, yeah?
My lord.
On request.
Interim order is there, kindly continue.
68, I'm there for the opposite party, they're enjoying the interim order. Any day next week, as per my.
Don't say anything, then it will come automatically. Don't request. Automatically come.
Interim order is there, but continue till then.
I am not saying anything, I'm not taking up the matter.
Number 72, it's a matter where your lordship has passed an interim order despite that the police arrested the lady person for which I had mentioned this matter. There's an interim order dated 15th of February. Last time when the matter was taken up, the lordship was pleased to allow the amendment, but that interim order continue was not there. Taking undue advantage of that, they are making us sit in the police station. So that interim order dated 15th February, if the lordship the last occasion, the last order did not.
15th February, there is an interim order.
The stay for the proceeding of.
Yes. Okay. Okay. The 15th February 2024 interim order has been continued subsequently also. Lastly, on 3/9/2024, it is, yes, right. Mr. Maharana, Land Counsel for the petitioner, seeks an adjournment in this matter to adjournment matter on his personal ground. Release the matter on such and such day. The interim order passed on 15/2/2024 shall continue.
Also, if your lordship, this matter pertains to compromise between the parties. One of the parties.
You bring them?
Yes, no, your lordship had issued notice. They have filed an affidavit in a bail application that they do not want to proceed with the criminal case. Therefore, your lordship had put it to today. If your lordship picks up a date, the matter can be disposed of. That is on record with your lordship.
They will not come.
They have, your lordship have issued notice thrice, but they have filed an affidavit before this honorable court that is on record.
They filed through lawyer or
through lawyer and through she has signed the affidavit in notary.
Next date, whenever it is given after 1 week, bring the accused out here.
Yes.
I'll see. Yes.
Picks up.
Bring the accused. Okay. Interim order to continue. Yes.
26. Okay.
Yes. Any mention? No. Thank you.